afternoon, guys. Well, I'm a little upset. The judge was talking to the attorneys this morning. Oh, hi, I'm Debbie. Welcome to my channel. In case you don't know me, I will be covering the Donna Adelson trial. I did not cover Charlie's trial. I did not cover any of the other trials involved in this case. I am playing catch up. I know a little bit about it, not a whole lot about it. I've seen a couple of hearings. I watched a little bit of Wendi Adelson's testimony during Charlie's trial. Other than that, I don't know much. Yesterday, we watched her emergency motion hearing, which was Wendi, her daughter, wanting to quash the subpoena for the defense. So the defense wanted her to testify for them. She also was subpoenaed by the prosecution to testify for them. So the defense cannot offer her an immunity deal. But hey Carla, but the prosecution can, and they did last time. It is not, this is the part I don't understand. It's not like blanket immunity. Like she can never ever be arrested. It has something, hey Jill, hey Wiggles. It has something, hey Judy. It has something to do with that she can't be prosecuted because of what she says in answer to the questions. I don't get the distinction. Because if she has knowledge of what happened, doesn't that make her guilty of doing it too? So if they say she isn't going to get in trouble for what she says, but she has knowledge of what happened, that would lead me to believe that she was involved. So if she has immunity because of what she answered, then that would mean she wouldn't be arrested. But apparently, what I've heard is that is not the case. I don't get it. And that what is being said from different sources around the internet is that they need her to convict. They needed her to convict Charlie, and now they need her to convict her mom. And as soon as these cases are done, that then she will be arrested and convicted as well. I don't know. I, for one, maybe Donna was the mastermind, but me personally, I don't think your family's going to kill your ex-husband for you without you asking for it, or at least wanting it done. Because don't you think you would be pretty pissed if your mom decided to kill your ex-husband without you wanting it or knowing about it or whatever? Like, I don't know. This family, I just don't get it. I don't. Like, they were already divorced, but Donna, who is this socialite from South Florida, when she's not from South Florida, I'm not sure where they're from. Her accent kind of sounds New York, but I don't know. I'm not good with accents either. So, but she's not like native Florida. You can tell by her accent. So I don't know what I classify. When she was on Wheel of Fortune, she said she was a domestic organizer. What the fudge is a domestic organizer? It's a fancy way of saying housewife. Whatever. I had the short pulled up a minute ago. Now I can't find it. I was going to play it for you, but now I can't find it. And I don't know why, but hey Terry, the little tiny blurb that happened this morning, I mean, it was so short with the attorneys and the judge, was only streamed through the Tallahassee Democrat, and they're still live. Like, but it's not showing anything. They're just, the chat is in there talking. But it won't let me rewind the stream to get back to the beginning where the judge was talking to the lawyers. And I don't know why. I do not know why. Oh, I knew there was a dispute about religion. So, this might be a very naive question, but which one was Catholic and which one was Jewish? And I know Jewish, you don't have to be the race Jewish to be Jewish. In the Shanna Gardner case, that's another very similar thing. But with them, it was Mormon and... No, I think it was just Mormon and nothing. He was Jewish, she was Catholic. Okay. You know, that's kind of something you need to figure out before you have kids. Okay, so I can't show you what the judge and the lawyers were talking about this morning, and I couldn't catch it all because I was streaming. I was trying to look at the closed captioning to see if it was anything important that was going to change anything. But I couldn't catch it. But they're in jury selection right now. So we're going to watch some old... Oh, and the other thing I found out last night, because I did a little bit of research. The attorneys, okay, so we watched the why does it sound like I'm saying that wrong? I'm not saying it wrong. I'm saying it right. But to me, it sounds wrong. Emergency. We watched the emergency motion hearing yesterday. And then we watched an old one from a year ago. That one had her son's attorneys in it when they were her attorneys. But that was because Charlie waived that confidentiality, which means they could have questioned him on the stand, and even if it had been a confidential conversation with his lawyers in the past, he still could answer the question and talk about things that had just been conversations with his lawyers. But Charlie waived that confidentiality, and then he took it back. So they had to recuse themselves as her lawyers because of the confidentiality agreement with Charlie. So that's why in the hearing we watched yesterday, she has different lawyers than the older one that we watched. Lori was on Wheel of Fortune too, and Sarah Boone was on Double Dare, an old Nickelodeon game show for kids. When she was a kid, she was on Double Dare. How are all these killers ending up on game show? Well, before. And Rodney Alcala was on The Dating Game. Oh my gosh. Note to self, don't ever go on a game show. Game shows turn you into killers. No, I'm kidding. I'm kidding. That's 4 people out of how many? Yeah, but Jewish, racially Jewish or religiously Jewish? Because that's different, right? Isn't it? I don't know. I was raised Baptist, and then we switched to Pentecostal. So I'm Protestant. I think that's what we're called, right? Protestant? Okay, so this was from February 20... Oh, if the mother is Jewish, they're religiously Jewish? Oh, that's weird. So they're genetically Jewish and religiously Jewish until they decide to pick whatever faith they want to be in, then. Okay, so this is from February 25th, 2025. And she's asking for relief because she got assaulted in the shower or something. And I've not watched this yet, so we're watching it together for the first time. Oh, cool. Are you Jewish, Jill? I mean, genetically.
You may examine when you're ready, Ms. Fulford.
Thank you, Judge. Ms. Adelson, at the commencement of the hearing on the motion to suppress, you said your name for the record, Donna Adelson. Can you tell the court how many times prior to your arrest for the charges that are pending in this case have you been arrested for criminal offenses?
Never.
And how long have you been incarcerated at the Leon County Detention Facility? Do you recall?
15 and a half months, 470 days.
And within that period of time, the 470 days, have you been held in the same location in the Leon County Detention Facility or different locations?
Different locations.
Okay, and your first location was where?
First location was in solitary confinement on a direct observation unit.
Do you know how long you were there?
50 days.
Okay. And where did you go following solitary?
To the N pod, like N is in November. It's an open pod, general population.
What does that mean, open pod, general population?
So I was with 60 some odd other inmates, all in one open area.
And you had beds in your room, I assume?
There were each sections off about 10 women. So, and there'd be a cement wall, and then there'd be another 10 women and a cement wall. So it was fairly quiet, actually, even with that many women, because we were separated in small groups, so it wasn't that loud.
Okay, and do you recall when you were taken out of the Inn like Nancy pod?
Yes, in August, they said they had maintenance to do, and that we would be moved to the annex, which is a building outside of the jail.
Okay, and so I'm not going to be specific as to dates, but you were arrested in November of 2023 in solitary confinement for 50 days to whatever date that took you to.
January 9th.
Okay, and then from January 9th all the way through some date in August of 2024.
Correct.
You were in the Inn like Nancy pod. And then you said you were transferred to the annex. Can you describe the conditions inside the annex, please?
So the annex is kind of a temporary type building. It's not a brick building. It's kind of like a temporary building, and it's and there are 66 women, all in bunk beds, all open. You're kind of one on top of the next. There's no separation at all.
So one big open room,
One big open room with 66 beds, yes.
Okay. And how long did you stay? So from August of 2024 until when? How long did you stay in the annex?
I was moved again on February 3rd, 2025.
Okay. Okay, and you were here when the gentleman was testifying about the call buttons to alert someone if you're having a medical emergency. Was there one of those in the N pod?
No,
Was there one in the annex?
no.
Okay. I'd like to start the motion for a bond that we filed in this case. As the court indicated earlier, one of the issues that we have raised are medical conditions that you're facing. So I'd like to start with your medical conditions and present some testimony to the court about those, okay?
Okay.
Okay. We're not going to go over every medical condition you've had since you've been incarcerated in the jail, but I'd like to start with one that you have that's causing you some pain in your leg and back area.
Yes.
Okay. Let me just start with this. Can you describe to the court the kind of pain and discomfort that you're having with this particular injury or issue?
Yeah, it's, I know what it is because I've had it in the past. It's sciatic pain, and I get like a pulling kind of shooting pain down my legs.
Okay. You said you've had it in the past.
You know what, Donna? That happens when you get old. Everybody gets sciatica when they get old. You should have thought of that. You know, nobody ever thinks, what is going to happen in prison when I'm old and sick? No, they don't. They just think, I need this person dead right now.
You mean prior to becoming incarcerated at Leon
Yes.
County Jail?
Yes.
Okay. And during the course of time before you were incarcerated at the Leon County Jail, did you seek treatment for that condition?
Yes, I did.
And what type of treatment did you obtain for that?
So I saw my orthopedist, and he gave me a steroid injection in my spine.
Okay. How long were you suffering from the sciatic condition prior to becoming incarcerated?
How long the last episode was?
Before you were incarcerated in jail, for how many years had you been suffering with the sciatic issue?
So no, I had it last about 10 years ago. I haven't had it all this time.
Okay.
But then it recurred a few months ago.
Okay. And what was the treatment that you were provided prior to your incarceration for your sciatic condition?
It was the steroid injection, and within 48 hours, it was gone. The pain was gone. It was amazing.
And where did they do the steroid injection? Where is that in your body?
In my spine.
In your spine. Okay. Is that an outpatient procedure, inpatient?
Yes, outpatient.
Outpatient? Okay. All right. And during the course of time that you've been in the Leon County Jail, did you start to experience the sciatic pain again?
Yes, it did.
And what did you do when you started to experience that pain?
I wrote a sick call, and I went to see the doctor.
Okay. Where do you get these sick call forms from?
From the nurse.
Okay. And when do you have the opportunity to see a nurse to get the sick call forms?
Well, they come twice a day. They come in the morning and they come in the evening.
Okay. And we'll get to what those times are at a later point. But if you don't get a form from a nurse, is there another way to obtain it that you're aware of?
No, that's the only way I've ever gotten it is from a nurse.
Okay. Do you recall approximately how far into your incarceration you started having the sciatic issues again?
I didn't have it until I was in the annex, so that was sometime over the last, I've been there 6 months. I don't remember the specific date, but I didn't have it before the annex.
Okay. And once you started experiencing it in the annex, did you complete a form to see medical attention?
Yes, I did.
Okay. And as a result of completing that form, did you have an opportunity to meet with someone in the medical center at the Leon County Jail?
I saw the doctor there, yes.
And what happened?
And I explained what I had, and she said, we do not treat that type of problem. We could offer you some Tylenol.
You can go to a neurologist, you can go to a neurosurgeon, you can go to a pain management doctor, you can go to an orthopedic surgeon, you can go to an orthopedist. There's all kinds of doctors that will treat that. You would think neurologist, but all kinds of doctors treat that.
And did they provide you with Tylenol?
My pain management doctor does mine, and he is a physiatrist. That's their pain management doctors are their title, I guess, is physiatrist. Not to be confused with psychiatrist. I don't have one of those. Physiatrist.
They did.
And has that relieved you of the pain that you suffer?
No, it's Tylenol. It's not gonna do what I need to have done. No.
Okay. So sometime since you've been in the annex, you made your first request for treatment for the sciatic issue. Have you requested treatment more than once?
Yes.
Okay, and have you received any additional opportunities to meet with any of the medical staff regarding this pain?
No.
Okay. What happens when you request treatment? You're not going to be able to
Hear anything, then I'll write another one, and I'll write, this is a second request, or this is a third request. And then I think they said I think I got an answer. They sometimes just answer it and give it to the pod officer, and she'll hand out papers at night, which is the response to your requests. And on that one, they said you're already getting pain medication for this. That was the Tylenol.
And the pain medication is just regular Tylenol?
Regular Tylenol.
Okay. At some point, did you have an opportunity to speak to someone in medical care regarding potential way to resolve some of the pressure in your leg for use of a medical mattress?
Yes. While I was down with the doctor during one visit, she said, you know what might be helpful, because you're sleeping on metal and the mattress is maybe a ½ inch thick, maybe. She said what would help is if I could get a medical mattress for you. I had never heard that term before, but I said, okay, if you think it'll help, that would be great. And she left the room, she went into another room, and then she came back in and said, yeah, I thought that would be a good idea, but they don't have it here. So my best thoughts for you would be to get a second mattress, so it'll thicken it a little bit, and that might give you some relief at night.
Okay. And did you obtain a second
I
mattress?
did,
And this was while you were in the annex?
while I was in the annex.
How did you get the additional mattress?
So the pod officer asked one of the inmates to go where they have extra mattresses. They have piles of 20, 30 mattresses there, to go get one of the extra mattresses and put it on my bed so that I had the extra mattress.
Okay. And during the time that you were allowed to have the additional mattress, did you get any relief?
Yes, at night, because I used to get the pains even if I was just lying down. And that definitely relieved some of the pain at night, so that was good.
Okay. And at some point, did they take the additional mattress away?
Yes, so on February 3rd, I was moved out of the annex to protective custody in the main jail building. And since I've been there, the officer removed the second mattress.
Okay.
She said, why do you have this? And I told her why. And she said, well, you can't have this.
And
Well, they took it away.
okay. And since the additional mattress has been taken away, have you started to experience worsened pain?
Yeah, it's worse.
Okay. And have you requested any medical treatment for that?
Well, I spoke to the doctor, I don't remember the date, shortly after it was taken away. I was down for a different reason, and she said, yeah, I thought it was a good idea, but if you can't have it, you can't have it.
Okay. All right. Now, the relief that you got when you were able to have the additional mattress, did that completely take away the pain?
No,
Okay.
no.
And do you experience this pain when you're walking, sitting? What?
So at the beginning, I was just getting.
Do inmates have to have a hearing if they need medical care? I thought there was something about no cruel and unusual punishment. Like, if you have a sincere medical need, are they not allowed? Judy. Are they not allowed to give you medical relief if you need it? See, this is why I was so worried about Karen Reed. I ain't worried about this one.
It when I was walking, so it limited the amount of walking I could do, but I get it when I'm sitting, I get it lying down, I get it all the time now. So it's not like I have it all the time. It comes and goes, but when it just comes, I could be sitting, I could be standing, it just happens.
Okay. We're going to go into more details about how it took place in a few more minutes, but for now I'd like to talk about, are there any other areas that you are experiencing any pain?
Yes, I have a problem with my left arm.
And describe to the court what that problem is, what you're feeling, what you're experiencing.
Okay, so I have like shooting pain from top here of my shoulder, down the outside of my arm, into my forearm.
Okay, and you're pointing to your left arm, is that the one you're referring to?
It's my left arm.
Okay, and so shooting pain down the arm, anything into your hands?
Yeah, the pain is like, it's like hot. It's like a burning pain, and my thumb, index, and middle finger have gotten like tingling. It almost feels like ants are crawling on them. It's like a numbness of those fingers.
Okay, and is this pain that you were experiencing prior to your incarceration at Leon County Jail?
No.
Okay, about when did this pain begin?
So I was assaulted by another inmate while I was here, the beginning of October.
October 2024?
Yes,
And when you say here, do you mean the Leon County Jail?
yes,
Okay. All right. Since you began experiencing that pain, since October of 2024, have you requested medical treatment?
yes.
And what has the response been?
They said they would take an x-ray, but in the meantime, I could have Tylenol.
Okay. And you said that was in approximately October of 2024. Have you been requesting treatment for that pain since October of 2024?
Several times.
Okay.
Yes.
And you heard the testimony of the gentleman previously. At some point, did they do an x-ray on your arm?
Yes,
And when was that?
it might have been February 3rd. No, that's the day I moved. It's shortly after February 3rd. I don't know the date.
Was it after you were removed and placed in protective custody?
Yes, it was.
Okay. Is the Tylenol helped with the pain that you're experiencing?
No.
After they performed the x-ray, were you called back into the medical unit?
It was for another reason, but they did call me, and they told me that the x-ray showed no fracture.
Okay, no fracture, that's what they were looking for.
That's what they were looking for.
Did they offer any type of physical therapy for your shoulder, anything at all?
No, I asked if they could do anything for it, and they said no.
Okay.
Tylenol.
She's got a pinched nerve. Tylenol is not going to help.
All right. Do you have any other medical conditions that you wanted us to address in the bond hearing that you're suffering from?
So I have a hearing issue.
Okay.
I have a problem. I evidently have very narrow ear canals, and so get the wax builds up in my ears to the point that, I mean, I have officers that say to me, "Are you deaf, Adelson?" When I don't respond to them, it's because I don't hear them. And so
So you say yes.
I did ask for help in the,
right?
I asked the doctor if there was anything they could do for me, and I told her what's normally done, and she's off in the wax, and then you come down 3 or 4 days later, and we use a bulb syringe to remove it. And I said, that doesn't work. I need a different procedure. And she said, that's all we can do for you.
Okay. And did you know, based on your prior treatment before you came into the Leon County Jail, that it required something other than the flushing system?
Yes, I did know.
Do you recall the name of the doctor that you saw for this condition?
Yes, I've seen him for years. Dr. Molina.
Okay. And Dr. Molino, how long do you think that you saw him for this condition prior to your incarceration?
I mean, several years.
Okay.
4 years, 5 years, I don't know.
Okay, and during the course of his treatment for you, how often would you go to have the wax removed from your small ear canals?
Yeah, every 3 to 4 months. If I waited longer than that, I couldn't hear.
Okay, and did he use a flushing method, or did he do something different?
No.
What did he do?
He used some kind of, I don't know what it's called, but it's some kind of an electronic device that he puts one end in my ear, and he's able to remove the wax using that device, that
Okay.
medical device.
And in your experience prior to incarceration, when you were having that procedure done, did your hearing improve?
Immediately.
Okay.
Yeah, immediately.
May I approach the witness, Your Honor?
You may.
Mrs. Adelson, I've shown you what the defense has marked as Defense Exhibit 1 for purposes of this hearing, and it's a report from Dr. Molina, your doctor. Could you review that just to yourself for a moment?
Okay.
Okay. Does that describe the treatment that he was providing to you?
Yes.
Okay, and it includes a recommendation that you continue to receive the same treatment, potentially with another ENT in Tallahassee, is that correct?
Yes.
Okay. This time the defense would offer Defense Exhibit 1 into evidence.
Any objections to defense 1?
No, sir.
Defense 1 is admitted. You may. Thank you.
During the time that you have, without disclosing any of the conversations, of course, but during the course of the time that you have met with counsel at the jail, have you had difficulty hearing us while we're trying to discuss your case with us?
Yes. I
And what
do.
about over the telephone? Are you experiencing difficulty hearing us in that way?
Yeah, the telephone is a problem.
Okay. Have you actually gotten in trouble by some of the guards at the jail because they've instructed you to do something and you weren't able to hear them?
Yes.
Has that happened on more than one occasion?
It happens on several occasions.
Okay. And have you experienced over the course of your incarceration that your hearing is getting worse and worse?
Oh, yeah.
Okay. All right. This is not a significant, I'm going to move on to something else now, and this is not a significant injury, but I did want to address this with respect to the type of medical care that you are getting at the jail. Did something happen to you recently where you cut your arm?
Yes.
Okay. Tell the court what happened, please.
So I was walking past the washing machine on my way to the restroom, and I bumped into there's like a metal bracket that holds the washing machine in place, I guess, and it was my fault. I bumped into it.
And what happened?
So I cut my arm pretty badly.
So what did you do after you cut your arm?
So the timing was it's kind of interesting because the med nurse was there doing morning meds. So I got onto the bleeding wouldn't stop. It was just pouring out. And so I figured I'll get on the line with the other girls and I'll speak to the med nurse. So I waited my turn and I got to the med nurse and she says, "Whoa, what happened to you?" And I said, "My fault. I just bumped into the washing machine and I cut myself." So she looked at it and she said, "Yeah, that's a problem." I said, "Yeah, can I get a Band-Aid or gauze or something, some antibiotic cream?" She said, "Yeah, I don't have any antibiotic cream and I don't have a Band-Aid." So I looked at her and I said, "Well, what should I do?" She said, "Well, why don't you use your toilet paper and put it on there?" I said, "But it's gushing. I can't put toilet paper on there." So one of the girls saw me and she said, "Oh my God." And she came running over and she opens up a sanitary napkin and she put it on there and it was filling the sanitary napkin with blood. And so another girl came over, she took the bloodied one away and she gave me hers too. And I was applying that. So I said to the nurse again, "We're not going to be able to stop it holding this. Isn't there something you can do?" She says, "The best I could offer you would be to fill out a medical request form." So I said, "You want me to do that now?" She said, "Yes." I said, "Okay, can I have a medical request form?" She says, "Oh, I don't have any." I said, "Well, what am I supposed to do?" And she said, "I don't know what to tell you." She says, "Maybe the night nurse will have that."
Okay. So this was just a couple of days before you were transferred to protective custody, correct?
Correct.
Okay. Do you recall that it was on Saturday, the 1st of February?
That is very disturbing to me as a nurse. I don't care if you are the most prolific serial killer in the world. Your job is to be a nurse. And if someone comes up to you and their arm is gushing blood, you need to help stop the bleeding. That is concerning to me. the sciatica doesn't bother me. That's from being old and sleeping on a cot. Yeah, but gushing blood. Now, when I was a nurse, we couldn't give people Band-Aids. But that was because I worked in a nursing home where a lot of times if you put a Band-Aid on an old person, like where they have really like thin skin and they hit some, like she did, you hit something and you tear the skin. Well, elder people have such thin skin that sometimes if you put a Band-Aid on it, it will actually, the skin will rip around the edges of the Band-Aid. So we would do like gauze over it and then wrap it with gauze. So we wouldn't do Band-Aids. But I don't think this was that kind of a situation where they just didn't do a Band-Aid. It was like she didn't even care that she had a cut on her arm. Like, do they not have a nurse that takes care of that kind of stuff and then a med nurse? Because like in the nursing home, you have a treatment nurse that takes care of stuff like that, and then you have a med nurse that gives out the medications.
It was a Saturday morning, yes.
Okay. And so about what time of morning would this have been if this was the morning med nurse?
It could have been 9 or 10, somewhere in the morning.
Okay, and when she told you that she didn't have any sick call forms for you to request a Band-Aid and you would need to get it from the night nurse, approximately what time does the night nurse come?
So the night nurse comes anywhere from 11:30 to 2:30 in the morning.
11:30 p.m. to
PM.
To what time?
2:30 a.m.
To 2:30 a.m.
Right.
And in the meantime, you were supposed to use the feminine pads?
I called my husband. He told me to elevate my arm, to wash it, to try to wash it frequently, just to keep my arm up, and that's what I did. And one girl brought over toilet paper, but that was sticking to the wound, so that wasn't good. So I kept borrowing sanitary pads to hold it.
Okay, and at some point, did the night nurse come?
Yes, she came that night.
Okay, and what happened when she got there?
She didn't have a Band-Aid either.
Okay.
She didn't have antibiotic ointment either. And I said, this has been going on since early this morning.
Judge, I'm sorry to interrupt, but I just turned around and noticed that some of the state's witnesses have re-entered the courtroom. We had previously revoked the rule for the bond proceeding.
All right. For anyone who is here to testify concerning bond, please step outside the courtroom. Ms. Dugan, is any witness you're intending to call currently in the courtroom?
I don't see any. I'm calling Miss Wilson and Deputy Collins.
Please continue with your examination, Ms. Fulford.
Thank you. So the night nurse came and the night nurse didn't have a Band-Aid either?
No antibiotic, no Band-Aid, and no, the form that I was told to ask her for, the sick call form. She said, I don't have them. We haven't had them in a while.
The night nurse?
The night nurse.
So how were you supposed to request, according to the night nurse then, how were you supposed to request assistance?
So I was actually fortunate because there was a sergeant with the night nurse. She accompanies the nurse when she comes there. And she took a look at what I looked like, and the night nurse said, yeah, that's a problem. And so the sergeant said, I'm going to make sure you get a Band-Aid, and I'm going to make sure you get a form. You'll get it by tomorrow. When I go back with the night nurse, she said, I'll run some off on the machine, some copies, and I'm going to make sure that you get it.
And did she?
The next morning.
Okay.
The next morning I got it.
From the sergeant?
From the sergeant, yes.
Okay. You got the Band-Aid and the call nurse?
Yes.
Call form?
The call form.
Okay. May I approach the witness, Your Honor?
You may.
Yeah. Adelson, I'm showing you what the defense has marked as Defense Exhibit 2. Do you recognize what's in that photograph?
Yeah,
And what is that?
that's a few days after I got cut, and it's the clear Band-Aid that they gave me to put on top.
Okay. After you got the bandage to put on over your wound, did you get additional medical treatment for the wound?
So no, not then, about, I don't know how many days later, but when I went down to medical a few days later, they said, how long are you wearing this bandage? And I said, I don't know, 4 or 5 days, whatever it had been. And they said, this should have been cleaned and changed every day. Why didn't you have that done? I said, I don't know. This is what they gave me to put on, and that's what I did.
Okay. The photograph, does that truly and accurately depict what your injury looked like the few days after it occurred with the bandage on it?
That's what it looked like.
The defense would offer Exhibit 2 into evidence.
Any objection to defense 2?
No, sir.
May I approach?
You may.
And at this follow-up visit, then did they change your bandage and clean the wound?
They cleaned it, and they put antibiotic cream on it, and
Okay.
they changed it, yes.
And did you get any additional treatment for the wound?
No.
Did you request that you get a tetanus shot?
My husband said, Donna, if there was rust on that metal, which there was, he said, you should ask for a tetanus shot.
And so did you request
So
it?
I requested it, and they did give it to me.
Okay. And then, as far as your medical conditions go, the last thing I want to talk about is something that I would give 2 different descriptions of, but I'm just asking the questions. You're the one providing the information to the court in your testimony.
Okay.
So this shortness of breath or heavy breathing that you're experiencing,
Right.
how long has that been going on?
It's been going on several months, probably at least 3 months, I would think.
Okay, and did it,
That's not a matter.
you're experiencing it then during your incarceration, did you have it prior to being incarcerated?
No, I did not.
Okay, what have you noticed about the
That's
breathing
correct.
and how would you describe it? Shortness of breath, heavy breathing, what?
I know, I guess it sounds like heavy breathing, it's shortness of breath. I've never had that before. I'm not a doctor, I don't know, I've gained more than 1/3 of my body weight here. The diet is all carbs, no protein. You get spaghetti with mashed potatoes, cornbread, and white bread, that's your dinner. It's very typical of what we get. And we've had no exercise at all. We're confined, especially in the annex. The annex, we've been confined to our beds almost all the time. Once in a while, we get a pod officer that lets us walk, so you can walk in a circle around the girls' beds. But otherwise, there's no, I mean, even if you want to get off your bed and just try to do stretches or wall push-ups or anything, she says, this is not an exercise room, there's no exercising here. We don't get taken outside.
Let me stop you. One of these issues at a time. So with respect to the time period when you've been in the annex, which was from August of 24 until recently, February of 2025, was it your understanding you're supposed to be taken outside a certain number of times?
Well, the inmate handbook says you get a minimum of 3 hours of outside time per day, per week, per week.
Okay, and during your time in the annex, did you experience a week where you got 3 hours of time outside?
We haven't gotten 3 hours in 6 months.
Okay. How many times did you go outside while you were in the annex?
Before you continue, Mrs. Adelson.
Yes.
We have 30 minutes left in the hearing. Ms. Fulford, I understand your client is disputing the adequacy of the care. We do need to move to the most pertinent matters. Please continue.
Okay, we're going to move off of that then. I do want to talk to you then about some physical issues that have taken place in the jail. The first one I want to talk about is an incident that took place in the shower, and we're going to do this one briefly. I'm sorry, how much time did you say we had, Judge?
30 more minutes.
Including argument?
Not including argument.
Okay. All right. The first incident that took place in the shower, could you just briefly describe to the judge what happened there?
Yeah, so I always, there's 7 shower heads, but I always take the same one because it's off in a corner, so I have a little bit more privacy than you'd have at the other ones, and so I would always shower there, and I was under the shower, and I was washing my hair, and I was the only one in the shower. I always go in early morning because there's nobody there. Most of the girls sleep, so I take a shower and I have a little privacy. And so I was washing my hair, and all of a sudden I felt a hand go up my back, like from the top of my butt up my back, and I yelled, "Stop it!" and I turned, and this girl said, "You like it?" And I said, "Get out of here!" And I started to scream, and she ran.
Okay. In the bathroom there, what was this? Which pod was this in?
This is in the annex.
In the annex. Okay. In the annex, are there guards positioned inside the area where you shower?
No,
Inside the area where you use the restroom?
no.
Okay. All right. The next thing I want to talk about is what transpired in October of, thank you, October of 2024, where you had said previously you were attacked. What were you doing? Where were you at, first of all, when that took place?
In October. So I was in the bathroom. It's 10:30 at night. I went in to brush my teeth.
Okay.
There are three sink stations in the bathroom. Each one has 4 sinks. And I was at the center station with my back to the door, and I'm a righty, so I was holding my toothbrush with my right hand, and I was balancing myself with my left hand on the sink. I was just brushing my teeth. That's all I was doing.
And what happened?
And someone came up behind me and pulled my left hand away from the sink and twisted my arm and like jerked it behind my back, like reaching up toward my neck.
Okay.
And
Did it hurt?
yeah, it hurt.
Okay. What happened?
It hurt. And I said, "What are you doing?" And she's, in the same breath that she did that with my arm, she said, "You're going to buy me commissary." I said, "I'm going to what?" And she said, "Unless you want those pretty white teeth knocked out of your mouth, you're going to buy me commissary." So I said, okay. And then she named a package that she wanted, and she's out. She was gone. She was just that fast.
Okay. How bad would you, how bad would you rate the pain at the time that she did that to you?
Oh my God, it was a 10.
Okay.
I didn't know my arm could reach that far back.
Okay. And what did you do after she did that to you?
So, kind of stood there for a minute, and then I just thought, okay, I'm gonna go back to my bunk. And I went back to my bunk, and I got under the covers, and I cried. I just stayed under my covers. I didn't come out.
Okay. During your entire time in the annex, did this particular inmate remain confined in that area with you?
She was in the annex the whole time.
Okay. And I know that you don't want to talk about who did this to you, because why? Why don't you want to disclose who it was?
There's one thing I've learned since I'm there is you don't love anyone because you'll be sorry you did. And I've seen that. And so I didn't even tell you for a while. I wasn't going to tell anybody. I didn't want to tell anybody. I didn't want. She's a big woman, and I was afraid of her.
Okay. Approximately how tall would you say she is compared to you?
She's over 6 feet,
Okay.
over 200 pounds. She's
Okay.
a very large woman.
Okay. Were you afraid of her?
Yeah,
Okay.
yeah, I was after that.
Okay. And you said that she demanded that you were going to start getting her weekly commissary. Did you do that?
Yes.
Okay. Let me, can I have just one moment, Judge?
Go ahead.
No, 10 is just the worst pain you've ever had. 1 is the least, 10 is the worst.
Your Honor, in order to move this along a little more promptly, I've requested of the state, and they have no objection. At this time, I'm going to offer into evidence State's Exhibit number 3. I'm sorry, I said state by mistake. Defense Exhibit number 3, Defense Exhibit number 4, and Defense Exhibit number 5.
The objection is taken.
No.
May I
They are
urge?
admitted. Thank you.
Ms. Adelson, prior to ordering commissary for this woman who attacked you, were you getting commissary for yourself?
So I have an account, and you can buy up to $40 a week of food, and so I use that account to buy food, but not what she wanted. She wanted packages.
Okay, let's make sure the court understands. When you say buy food, is there normal commissary through the jail where you were getting your commissary?
Yes.
Okay, and that's what you were spending $40 a week on for yourself?
Aramark, yes.
Okay, and what kind of items are you buying for yourself off of that?
I try to get some protein. I buy tuna fish with mayonnaise and,
Substitute meals, if you will?
Yes.
Okay, no noodles of any kind?
no.
Okay, all right. Now, is there a separate way that you can order commissary on the outside for inmates?
Yeah, I
Okay.
can't do that. It would have to be ordered from somebody. You have to ask somebody on the outside to place the order.
Okay, and when you referred to packages, is that the method that the woman who attacked you said she wanted you to get for her?
That's what she asked me to get her, yes.
Okay, and these packages cost about $40 each, is that correct?
40 and then $10 for packaging or shipping, so it's $50 a package.
Okay, and during the course of your time in the annex, while you were still in the annex, on just about every week, did she continue to find you in the bathroom and demand what packages that you would get ordered for her?
Yes,
And-
she must have been keeping an eye on me, but when I was in the bath, those are the only times she would approach me is in the bathroom, and she would tell me what she wanted for that week.
And did you make those orders through your husband?
I called my husband. I didn't tell him what happened. I just called him and said, honey, I want some extra food. Would you mind ordering some packages for me? And he said, sure, honey. And he
Okay.
did.
And he did that. And at the time that your normal canteen or commissary would be delivered, is that when the extra packages would be delivered as well?
Yes, all at the same time.
Okay, and in the course of things, you would go pick up your canteen and then her extra packages, is that
Yes,
right?
yes.
And where did you keep her items when you got back to the annex?
So it was, you have to carry your bin up, and they put the package, they open up a plastic bag and they loosely put all the stuff in the bin. So it was all in a bin that I would take back and put under my bed.
Okay, and did you keep her eye care packages separated from your canteen?
Yes.
Okay, and how is it that she would receive her packages? How did she get the
So
food?
she would send, I used to say her minions, she used to pick different girls to come over to me, and they would say, package up 4 soups and 3 bags of chips. And the first time I didn't know what she wanted me to do, and she said, it's for, and she'd mention her name. And I said, well, how am I supposed to do that? She said, just put it in your shirt, I'll meet you in the bathroom. So I would load these things in the top of my shirt, and I would hold the bottom of my shirt like this so that nothing would fall out, and I'd go to the bathroom, and then somebody would follow me in there, and she would take it out, transfer it into her shirt, and walk away.
And that continued from the time that she first yanked your arm behind your back in October all the way until you, in fact, did you receive your last packages for her?
So the last package came, I was into protective custody on a Monday, and Tuesday, the commissary came with those packages and brought them to me.
Okay, and do you have that extra food in your protective custody room now?
They're sitting there. I don't eat that stuff, so it's all sitting on top of my bunk.
It's made up of noodles and chips and things of that nature. Is that correct?
That's correct.
Okay, all right. I want to talk briefly about your time in protective custody. How big is the room that you're in?
6 by 9?
Okay, and are you in this room by yourself?
Yes.
And is the door, with the exception of when they allow you to come out, is the door kept closed all of the time?
It's supposed to be kept closed.
Okay, all right, and you're given, I'm kind of leading here, Judge, to try and get us through this, but you're allowed to come out of that room 1 hour per day on Mondays, Wednesdays, and Fridays, is that correct?
That's correct.
And on Tuesdays and Thursdays, you get to come out for 20 minutes, is that
20
right?
minutes.
Okay, and on the weekends, you don't get to come out?
Not at all.
Okay, make sure you don't talk over me, okay?
I'm sorry.
That's okay, we're talking over each other.
Okay, I'm sorry.
So Saturday and Sunday, you don't come out at all. During your hour 3 days a week and your 20 minutes 2 days a week, is that when you are given the opportunity to take a shower?
Yes.
If you have time to walk, that's when you walk?
So on an hour day, I'll walk for 40 minutes or about, and then I'll take my shower at the ends of that, so I get my shower in.
Okay, and laundry also? That's what you use that
All
time
of
for?
that, yes.
Other than that, you're locked inside that room?
Yes, I am.
Okay. Now, it was your understanding when you were put into protective custody that there's not ever supposed to be anybody out around you, is that right?
That's what I was told.
Okay, but protective custody is actually attached to a pod, is it not?
Yes.
And what pod is that?
M-Pod, like Mary.
Okay. At some point, did you learn that this individual who attacked you was also, at least for some period of time, in that same area?
I'm not sure where she was. She might have been.
Okay.
I didn't see her.
You didn't see her?
I
Okay.
heard that she was there, but I didn't see her.
Okay. Now, you have testified earlier that different guards have kind of different rules that they follow inside the jail. Is that fair to say?
That's fair to say.
Okay. During the time that you've been in protective custody, when you were told you should not be around anyone else in the pod or otherwise, have there been times when guards would have you around other inmates?
Yes.
Okay. In fact, was there an occasion where another girl came and knocked on your door wanting you to give her food?
Yes.
Yes? Okay. And what happened when you said you would give her food?
I said, I have all that extra food. I don't mind giving it to people. So-
Okay. And so how were you going to give it to her?
Well, that's what I said to her. How am I going to get this to you? And so she gave the guard a high sign, and the guard buzzed the door open, and it was her and a friend of hers, the two of them, and they'd only stepped in my room like a foot, came in, and I gave them some soups.
Okay. Is that the only time that you've been around other people since you've been put in protective custody, or have there been other sorts of
There have been other
situations?
times, like yesterday, the officer buzzed my door, so I guess there was something she wanted me to do, so I opened my door, and I came out, and there were maybe, I don't know, half a dozen girls watching TV. I walked past them, and I asked the officer, what did you want? And she said, oh, I'm sorry, Miss Adelson, I didn't mean to buzz you, just go back to your room. I said, okay. So
Okay.
I turned around and went back.
Okay. We have to move along a little bit faster here. So one of the things that's been a big issue for you is lack of sleep. So we're going to just kind of go through this quickly for the court. But you testified previously that the nighttime medications come between 11:30 p.m. and 1:30 or 2 a.m. Is that correct?
Yes.
Okay. And part of the nighttime medications that you get, is there something in there to assist you to go to sleep?
Yes.
Okay. And then you get the medication. About how long after that is it before you can go to sleep?
From the time I get it, probably a half hour.
Okay. All right. And what time are you woken up for breakfast?
Between 3 and 3:30.
Okay.
Last night was 3:10. Just within that half-hour range is when it comes.
Okay. And once you're woken up for breakfast, are you capable of going back to sleep?
No.
Have you tried to go back to sleep?
Oh, my God. Yes, I try.
So that period of that block of time that you get from the time you fall asleep after your night meds until you're woken up for breakfast, that's the only sleep that you're getting while you're incarcerated?
That's it.
How has that affected you?
So, listen, I know older people don't need as much sleep as younger people, but I need more than 2 hours a night. I need more than a good night is 3. One night I had 3.5 hours. It's not enough sleep to stay focused. I mean, I feel like I'm foggy sometimes because I'm sleepy, I'm tired, and I can't go to sleep. They've got people screaming and yelling. They bang on the doors, they shake the doors. It sounds like a drum in there. It's horrible. So I can't sleep with all that noise going on.
Okay. Do you have legal documents that we have provided to you or prior counsel has provided to you that you need to review to assist in the preparation of your defense?
Say that to me again.
Sure. Do you keep legal documents with you that you're supposed to be reviewing to assist to prepare for your defense?
Sure, I've got two bins full of them.
Okay. Are you having difficulty completing the tasks that we're asking you to do because of your lack of sleep?
Yes.
Okay. All right. I want to talk to you for just a second. You're able to make calls to your lawyers off of your tablet, correct?
Yes.
And those are supposed to be attorney-client privilege calls, correct?
Yes.
Okay, and they're not recorded according to what's said on the recording when you make the call, is that
That's
right?
right. That's
Okay. During the time that you were in the annex, were you in a situation where you could be away from everybody so that you could make those calls without anyone hearing?
No, I had to make the calls under my blanket because you couldn't hear me. I certainly couldn't hear you. So I would go under my blanket with the tablet and I would call you that way.
That didn't keep the other inmates who were standing right next to you from hearing?
It is what it is.
Okay, was there a time when you and I were speaking and when you pulled the cover back, there was actually a guard there listening to your call?
Yes, there was.
And during the time that you and I are having conversations, do you also experience the same kind of problems with the phone that you had heard that Charlie had while talking to you, where the calls are dropped, et cetera?
We've had it numerous times.
Okay, are there times where we're not able to hear each other on the phone calls?
Yes.
Is there static on the phone calls?
It's static, and now you've been complaining because I have this shortness of breath, so you say I'm breathing very heavy, and it's hard to hear me,
Okay.
so it's difficult.
All right, let me ask you a few questions. We're requesting that His Honor allow you to be out on bond pending your trial so that you can assist in the preparation of your defense. If His Honor ordered that you reside here in Leon County and not leave Leon County until the conclusion of the trial, would you agree to do that?
Yes, of course.
If he placed you on an electronic monitor, would you agree to take that?
Yes,
Okay, if he required that you have a curfew from 7 o'clock at night until 7 o'clock in the morning, would you comply with the curfew?
I would do
Do
that.
you have the ability to do these things?
Yes.
Okay, you have the ability to get housing here in Tallahassee where you could live with your husband.
Sure.
Outside of the curfew, you can leave to go meet with your lawyers, medical appointments if you need medical appointments, coming to court, those type of things. Would you comply with those orders as well?
Yes, I'd be grateful just to get a night's sleep. It would be great.
Okay. If he ordered that you had to surrender your driver's license during the pendency from now until the end of the trial and not drive, would you agree to comply with that?
Yes, I would.
Have just one moment, please. Of during the time that you were speaking with the doctors and they said that they didn't give you the treatment, perform the treatment for you?
No.
I don't have anything further.
Okay, so the incident in the shower, after you let the inmate know that you did not like what she was doing by telling her, and that inmate's no longer, or you didn't disclose the name of that inmate, but you did tell the investigator that that inmate is no longer in jail.
She left shortly after that.
Okay, as far as the arm twist incident from October of 2024, you said you reported that, okay? And you wouldn't give the name, you said you wouldn't give the name of her to the investigator either, okay?
No.
But you do know that if you would give her name, that instead of you being separated from the pod, she could be separated from you and you could be back with the general population.
Yeah, but she's not the only one that could hurt me. That's why I wouldn't do it. She had a half a dozen.
Violence by her or anyone she's with after that October
No.
24 incident?
No, that was it.
And by being in solitary confinement, does it give you an opportunity to have a quieter space where you can prepare for trial?
I guess it would be a quiet space if I could get some sleep and I would be able to concentrate on what I'm supposed to do. Yeah, I do.
Okay, and when that happens, are you in a room alone with him or her or both?
Yes,
Okay.
yes,
And y'all are able to have conversations then that are private?
yes.
For the sciatic nerve, in December of 2024, were you offered a solumedrol steroid injection for that pain that you declined?
I am going to object to the use of the medical records by the state based on a prior objection.
Student, do you have an ability to show that these records were not a part of what was obtained by Investigator Newland that is still disputed?
No, these are part of what was obtained by Investigator Newland. But my understanding is that the defense would have opened the door to this by asking her about all of these times she was seen by medical staff and what basically was not done for her.
As that, I will permit the witness to answer. You may answer, Ms. Adelson.
Could you ask me one more time?
Yes, ma'am. For the sciatic pain that radiates down your right leg, were you offered a solumedrol, a steroid injection, and then after that, a Medrol, so a steroid dose pack that you declined until you were able to speak with your physician?
No, I told her that in the past I had gotten a steroid injection in my spine, and she said, we don't do that. I could offer you, and it was a Medrol dose pack, I think.
A solumedrol
I can offer
injection?
you that, but we don't do that. And having had sciatica twice in my lifetime, I know what's been done each time, and I know that worked. And so she said, we can't do that. We don't offer that. You would need to see a specialist for that.
Okay. I'm going to show you this page. I'm looking at the encounter from December 13th, 2024 at 3:22 p.m. What does it say? Offered patient a solumedrol injection and then starting tomorrow a Medrol dose pack. Patient requested decline until she can speak with her physician.
I don't know what a solumedrol injection, but she told me they don't give steroidal injections in the spine. She says we don't do that, and I don't recall her offering an injection. I do remember she said I could give you other medication.
Solumedrol injection is the steroid injection. That is the steroid injection. If they do it into your spine, they have to do it under fluoroscopy, which is basically x-ray. So they can see the spine, the space in the spine, so they don't hit the nerve. So they go near the nerve and not hit the nerve. But you can also do that injection into the muscle, because that nerve, what happened, that muscle compresses that nerve. So you can put the steroid injection closer to the nerve, which is better. You get a better result from that. But if you can't get it into the muscle, it will relax the muscle and ease it up off the nerve. But no, Miss Rich little fussy pants has to have it in the spine.
But I've been there. I've done that. I know what happens with sciatica, and I know what needs to be done. That's not going to be the answer.
For your arm and shoulder pain, isn't it true that you reported you had mild pain?
It's better than nothing. Why don't you try it? Instead of crying like a baby on the stand, try it. When you're in that, okay, there's a lot of spoonies in this chat. Y'all, when you're hurting, you try anything you're offered, correct? Jeez.
Pain in your left arm and
No,
shoulder.
I heard that gentleman say that before. I couldn't believe it. I told you that I had severe burning pain down the outer part of my arm. I never used the word mild pain. So I don't know where they got that from, but that's not what I said.
Okay. I'm going to show you the encounter from February 3rd, 2025 at 2:29 p.m. Under musculoskeletal, does it say positive for left upper extremity limited ROM, range of motion, comma, mild pain.
That's what it says, but that's not what I said. No way is that pain mild.
And so that's just what the doctor would have written down, but you're saying that's not what you told the doctor or nurse?
I did, had that been given to me and I read it and I had to sign it, I would say I never said this. But I'm telling you, I never said mild pain.
Okay.
It's shooting hot pain down my arm.
For that injury, you did have an X-ray, and they did go over that X-ray with you and let you know that there was no fracture or
Sure, that's what she told me.
shoulder or arm.
No, there's just pain.
And they also went over your chest X-ray results with you to let you know that your chest X-ray appeared clear.
Yes.
Okay. You ultimately received the Band-Aid and Neosporin for the cut on.
Part of my chemo, the week of my chemo, I had to be on prednisone for 7 days. The whole week. Like, I took it the day chemo started and then had to be on it the whole week. So the day I went to the clinic for the chemo and then the whole week. And we called, y'all know I don't like the cuts, but Travis and I called those my bitch pills. Because that whole week, he couldn't stand me. But he stuck it out. He's such a trooper.
On your elbow?
Yes, I got that on, I think it was Saturday. When did I get that? On Monday?
Okay, so within a day or two of the cut occurring?
Yes.
And you said that if you are given a bond, you will reside in Tallahassee, you will follow court orders. But when you were afraid of being arrested right after Charlie Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
I wasn't afraid of being arrested.
What were you trying to get to the airport in time for? In that jail
My
cell?
husband and I were literally shocked and traumatized at what had happened to Charlie. And he said, we need to just get some peace. We need to catch our breath. We're going to go away somewhere. And I thought it was a good idea because I couldn't think straight. I really couldn't think straight. I was so upset, and so was he. And it was his idea. He said, sweetheart, let's go, just get away. We're going to just get away somewhere so we can have some time to think.
Okay, so your testimony is that you weren't trying to go to Vietnam because you wouldn't be able to be extradited from there.
So my husband actually had said, we've been to Vietnam before. With friends, we were on vacation.
We should start calling her Veruca. Tana, you have a new name. It's Veruca now. Your name is Veruca.
And it really was like a place of peace. And so he said, if we go to a non-extradition country, then if the law enforcement decided that they wanted to arrest you or me, whatever, he said, we won't be sitting in a foreign prison waiting months to go back. We could buy a ticket and we could go home. And my understanding was that I could go home and I could turn myself in if that's what they wanted.
What? No way.
Okay, but you were hoping to make it out of America in time before you were arrested, right?
I wanted to get away. He wanted to get away. That's what we wanted to do. And it wasn't,
So you wouldn't get
we
arrested.
spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said there's no, what were their words? There's no pending charges and there's no warrants. So you want to go, go. And so I thought you asked your attorneys and they tell you that. I'm going.
But Dan did tell you, as you say in the jail call, that Knowing what they're thinking up there, I don't know if you'll make it out in time. I really don't. But he said you might, or you might get to the airport and they'll stop you. It could happen.
That's what he said.
Right. So you went to the airport knowing that it could happen. They could stop you at the airport. You could end up being arrested.
Yeah, that's what Dan said.
Right. And when you were looking at places to go those couple of days after Charlie Adelson's trial, you were specifically looking, though, for countries that did not have extradition with the U.S.
For the reason I just told you.
Right. And the reason that you're saying that you were looking for countries with no extradition was so that you could get back faster in order to be arrested in the U.S.
No, that's not what I said. It's because, I don't know, maybe we watch too much TV or too many movies, but I've seen movies where people are stuck in like third world prisons and waiting and waiting and waiting. And my feeling was, this is not what we want to happen. If the state says they want us to come back, we'll buy a ticket, we'll come back on our own terms. We don't have to be sitting in a jail somewhere. We'll come back home and turn ourselves in.
Couldn't you have done that no matter what country you went to?
No.
No?
No.
You couldn't have found out that you had a warrant for your arrest and come back if there was an extradition
Well,
policy?
not if they would, I'm not in law enforcement, but it appears that they would notify law enforcement in that country, and then they could hold you in a jail for God knows how long, and I didn't want that to happen. So he said, well, that's why we'll do it this way, honey. That way, if they do notify us, so we get a phone call from our attorney or from law enforcement, then we'll buy a ticket, we'll go home.
Okay.
And so it would have been on our terms. That was the point. That was the reason that he thought that was a good idea.
And your
Before you
testimony,
continue, Ms. Dugan, we are over time. If you please can get to your most pertinent questions.
yes, sir. I guess your testimony ultimately, though, is that you were not trying to go to a country with no extradition because you were trying to avoid being held accountable for this charge. That's your testimony?
Being held, I didn't do this.
Okay.
Being held accountable for this is not what happened.
Being arrested for this case.
Being arrested,
Right. That was not what you were trying to avoid by trying to go to a non-extradition country.
we were trying to get our heads on straight and just breathe.
That's all I have. Thank you.
Any redirect examination for Mrs. Adelson?
Just one question, Judge.
You may proceed.
The testimony was you were offered an x-ray. You were never offered an MRI for your shoulder, were you?
No.
Thank you.
You may step down, Mrs. Adelson. Deputy, please assist her to her seat. Does the defense have any other?
That was it. We're back. Okay. No. Did it go too far back? It went too far back. Why is there no sound? And why can't I go back to the beginning of the feed? They've done a soft tissue. And more than likely that's bad. It's on a rotator cuff. Why don't we have sound? Oh, I guess they've got them all in the court now. Earlier, they weren't in the courtroom. I guess they were doing questionnaires or something, maybe. But look, is this not the weirdest thing? It won't let me go back to the beginning. All it'll do, I can stop it and start it. That's all I can do. Okay, I know there's some other hearings. Well, I keep seeing them, but it's just clips from them. I know there's more. Dang it. Of course, now that I'm looking for it, I can't find it. Well, dang it. Hang on, y'all. I'm sorry. I should have been more prepared. Oh, here we go.
And we now meet Donna Adelson.
Here she is on Wheel of Fortune.
From Coral Springs, Florida. I want to hear all about you, Donna. Let's go.
Well, I'm a domestic coordinator.
A domestic coordinator.
Yes. I'm responsible for the activities, classes, and lessons of my son Robert, who is 16, Charlie, who is 12, Wendi, who is 10, my husband Harvey, who's in the audience, and my dog Sam.
Donna.
F.
Yes.
Mischief maker.
Yeah, that's it, Donna.
Mischief maker. Mischief maker. Dadgummit. Oh, cool. Wait a minute. Y'all just talk amongst yourself. I think this is the part I was trying to find. There's our seal.
Just the indictment that has actually been filed, yes.
Well, I'm referring to the statement in case the jurors can think about what question you're already asking them that.
Oh, yes, go ahead.
It might be easier if I
So I-
Microphone. The court reporter looks like that chick from that 70s show. The mom on that 70s show. I don't see
Those
a
are
list.
questions that are highlighted.
And stating the case started on the prior page.
And you're just asking for this to be read?
Yes, sir.
Okay.
Then don't fold them.
Trying to see when this was given.
This was in charge.
I have a clean clothes
Right, right.
basket
But at the
and a
point
dirty
in which
clothes
it was
basket.
given. Does someone have this portion printed out? Please. The group? Okay. Okay. Are they first 14 in there, everyone else over there?
Doing something? We're 11 minutes into this and we haven't done anything yet.
We still waiting for anyone outside? Okay. Everyone can be seated. Patricia, once numbers 2 and 15 have been located, they're just to be seated in the back. We're going to move forward with what we have right now. Good morning, ladies and gentlemen.
Good morning.
Okay, not great. Let's start again. I'm giving you a proper greeting, looking you in your eyes. All I'm asking back from you is for the same. Good morning, ladies and gentlemen.
Good morning.
There we go. I'm Stephen Everett, one of your circuit judges for the Felony Criminal Division here in Leon County. You have been summoned here today as prospective jurors in the case of the state of Florida versus Donna Adelson. This is case number 2023 CF 3226. This is a criminal case. The state has charged Mrs. Adelson with the crimes of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. You will notice at times during this jury selection process today that I will be reading to you. It is not that I do not wish to have a normal or free-flowing conversation, but rather any explanation that you receive on the law during this process must be uniform and it must be specific according to the Florida Supreme Court. Is the state ready to select a jury in this matter?
Yes, Your Honor.
Is the defense ready to proceed as well?
Yes, Your Honor.
And for the record, I'm noting that Mrs. Adelson is present in the courtroom with her counsel. I believe downstairs a few minutes ago you spoke with Judge Ashenofi Richardson, where she went through the qualification process with you concerning who is actually eligible to serve as a juror in the state of Florida. What I'm going to do, just to make sure that anyone at this point would otherwise qualify to be excused by statute, I'm just going to confirm this information. By a show of hands, is everyone who has been brought up this morning at least 18 years of age or older? Please raise your hands. For the record, all prospective jurors have answered in the affirmative by raising their hand. Are each of you citizens of the United States of America and residents of Leon County, Florida? Please raise your hands if this is so. Again, for the record, the prospective jurors have raised their hands in the affirmative. Are all of you residents of Leon County? Please raise your hand if this is true. Again, the prospective jurors have raised their hands. Thank you. Do each of you possess a driver's license or identification card that's been issued by the Department of Highway Safety and Motor Vehicles, or have you executed an affidavit as to your eligibility to serve as a juror? Please raise your hands. Once again, for the record, the prospective jurors have raised their hands in the affirmative. The next series of questions are basically just going to deal with whether anyone should be excused at this point or is ineligible to serve. Has anyone been previously convicted in a state or federal court of any felony crime or a crime of dishonesty and you have not had your rights restored to you? If this describes your situation, please raise your hand. For the record, none of the prospective jurors have raised their hands. Are any of you at this time under current prosecution for any crime, either in a state or a federal court? Please raise your hands if this describes your situation. Once again, for the record, none of the prospective jurors have raised their hands. As to matters in which you can be excused by law, is any person here a sworn federal, state, or local law enforcement officer or investigative personnel? No hands have been raised in response to the court's question. Anyone an expecting mother or a parent responsible for the full-time care of a child under 6 years of age? All right. Sir, if that is, please form a line and I will deal with you momentarily just in the middle. Is anyone present 70 years of age or older? No hands have been raised in response to this question. Has anyone performed state jury service within the last year? And by last year, what I'm referring to would be August 19th, 2024 to today.
Oh, cool.
No hands have been raised in response to that question. Is anyone responsible for the full-time care of a person with a physical or mental incapacity who is incapable of caring for themselves, and your presence will create a hardship? No one has responded in the affirmative to that question. Is anyone a full-time student between the ages of 18 and 21 years of age who is attending a high school, state university, private post-secondary educational institution, Florida college system institution, or career center? Right, if you please can stand behind the gentleman in the aisle.
18 to 21. What if you're a displaced homemaker that's been divorced and going back to school to learn to support your kids?
believe we also have one new one by statute. Has anyone given birth within the 6 months before the reporting date on your summons, and you are seeking to be excused for that reason?
Oh no. I would have called and been like,
No
hey,
hands
look.
have been raised in response. Right, one by one, if you please can come forward, and I will address the issue.
Wouldn't you? Like, if you just had a baby, wouldn't you be picking up the phone and being like, I just had a kid. I can't go. Because that's what I did when my jury duty was on a chemo day. I was like, nope, sorry, can't make it. I got chemo that day.
But you responded to your questions, or to the court's questions.
What? That was it? It didn't show the part where he was talking.
Do you swear
or
or affirm the testimony you're about to give will be the truth?
Wait, what was that?
Do you swear or affirm the testimony you're about to give will be the truth? Take your seat. Please speak loudly and clearly. You can adjust the microphone if you need to.
Okay, that's from Charlie's trial.
Good morning, Mr. Geiger. Good morning. Please spell your name.
I'm gonna try to watch it. Yeah, he's a little much for me too. I think he's a good journalist. I just nothing against him, nothing bad. He's just he just comes at things differently than I would, I guess. And then he does have quite a vocabulary that I don't think is necessary. Like, even if you want to talk that way in your everyday, normal, don't do it on stream. Unless you're just the person that doesn't care about alienating certain groups of people. You know what I mean? Like, I personally don't like it, but if that's the way you want to talk in your private life, that's fine. But I'm not going to watch you if every other word's going to be the F word, you know? But I need to get caught up on this case, though, so I'm going to try to watch it. And I don't know.
Respective jurors, I should say, are on their way.
He's like an in-your-face kind of a journalist. Which I guess we needed in the Karen Reed case, but, Are they still in the courtroom, and do we have sound? Oh. I guess they... Hang on.
On July 18, 2014, FSU College of Law professor Dan Markel was shot while seated in his car. This happened in the driveway of Markel's
Hurry up! StreamYard!
neighborhood.
The stupid
The killers
stream
traveled
rewind
to
or nothing.
Tallahassee from Miami to commit the murder in a rented silver green color Prius. The defendant of Dan Markel and has entered a plea of not guilty. I will also now read to you the material part of the indictment that has been filed against the defendant.
The sound is horrible. So does this mean they picked a jury already?
Count 1. It is alleged that on or about July 18 of 2014, Donna S. Adelson in the county Leon and state of Florida did unlawfully kill a human being, Daniel Markel, by shooting with a firearm, and the killing was perpetrated from or with a premeditated design or intent to effect the death of Daniel Markel, contrary to the Florida statutes. Count 2. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did agree, conspire, combine, or confederate with Charles Adelson and or Catherine Magbanawa and or other persons to commit first-degree murder contrary to the Florida statutes. Count 3. It is alleged that beginning in 2013 until October 1st, 2016, Donna S. Adelson in the county of Leon and state of Florida did solicit another to commit first-degree murder, and in the course of such solicitation, commanded, encouraged, hired, or requested the person, Charles Adelson and or Catherine Magbanawa, and or other persons to engage in specific conduct which would constitute first-degree murder, which resulted in the death of Daniel Markel, contrary to the Florida statutes. The statement of the case and the indictment I have just read to you are not evidence and are not to be considered as evidence or any proof of guilt. You must not be influenced by the fact that an indictment has been filed in this case. It is merely a formal method by which the state makes an accusation against the defendant. We are now going to talk to each of you individually and privately about this case. Some of you may be excused. The rest of you will remain to participate in the next phase of the jury selection process. Individual voir dire is time-consuming, but will go a lot smoother if you are prepared to tell us the information that we need to know. These are the basic questions that you will be asked, or some variation thereof. What do you know about this case? What sources have you obtained this knowledge from? Based on what you know, do you have an sense of guilt or innocence? Can you set aside your present knowledge, disregard it, and render a verdict solely on the evidence presented in the courtroom? Can you be a fair and impartial juror? Do you have any reason that you cannot serve on the jury for potentially up to 3 weeks? It will save us all a lot of time if you think about these questions and be prepared to give us a prompt answer when you are called back. The last question that we will discuss with each of you individually deals with hardship. We expect the jury selection process to take until Thursday of this week. After that process is complete, we expect the trial to start on Friday and last for 2 weeks. All in total, we expect the proceedings from today will take up to 3 weeks. We understand that it is a burden for anyone to serve for that length of time. However, we cannot make our system of justice work unless we have good people that are willing to do their civic duty and serve as jurors. Similar to military service, we do have to call on our citizens to make sacrifices, and jury duty is one of those times. You will probably never be called on again to serve in a trial of this length and nature. However, I understand for some of you, service in this matter may not be possible under the circumstances. To give you a little more information about what this will involve, you will notice is you will be able to go home as you normally would and return the next day. For the most part, we will work a regular business day, but on occasion, it may become necessary for us to work a little bit longer based on the witness schedule. I will do my best to adhere to a regular schedule each day, so please give some thought to whether any of you may have a major problem, including a physical issue that would prevent you from giving this case your full attention for the time period in which we are discussing. Please be patient with us. We will be working as efficiently as we possibly can. The bailiffs, clerks, and court administration will be assisting in the courtroom. Please follow the bailiff's or clerk's instructions. Do not discuss this case while you're waiting, here, or anywhere else until you've actually been excused. Do not read or listen to any media accounts on your phone or anywhere else until you've been excused. Also, you are not to speak to each other while you are waiting to be examined by the court and the attorneys. You may read your phones. There are some magazines here available, provided as reading material, but ultimately you are not to speak to your fellow prospective jurors. Again, you are not to seek out any information about this case, but you may silently either read your phones, read the reading material that has been provided, or even if you want to, get some shut-eye, don't start snoring, but you're not to speak to each other. Are there any questions about this before we get started? Very well, if the parties can come to the jury room at this time, we will get set up and then we will start summoning back each of the jurors.
Dang, I thought they were done. Of course they're not done. That would be too easy. Well, now I can't get it out of full screen. Oh, wait. There we go. I've never seen a stream that you could not rewind or fast forward or anything. But this is the Tallahassee Democrat. I've never streamed anything from there before. What now? Harvey wigs out at Donna Adelson's hearing. But that's not. I gotta find a good one. I can't use anybody else's. That was what we watched yesterday. I found them all over the place. And I was like, yep, we're going to watch that one, and we're going to watch that one, and we're going to watch that one. And now that I want to watch them, I can't find them. There's no way everybody took them down. Yeah, my cousin's gonna, she's got a whole bunch of glow-in-the-dark yarn. She's gonna give me some of hers. Dang, 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 dang. Why can't I find this? It was all over the place the other day when I planned on doing this today. And now I can't find any of them. Jeez. Here, we'll watch the final pretrial hearing because I can't find the other ones. I'm going to make ghosts, little ghost dolls out of them. Ghost plushes, whatever you want to call them, for Halloween.
I'm being told we're going to hit a break since the judge apparently is just taking a pause here, maybe taking it all in, deciding what he's going to take up first. We'll do that, and we'll go back into the courtroom live and watch this hearing, the final hearing before Donna Adelson's trial.
Matriarch of the Adelson family gets arrested.
Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markel.
Prosecutors say a bitter
With the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking that the court exclude that file.
Mr. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first, and what is your argument as to hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendi Adelson should respond to the pleadings. So it's very, very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's their way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Perhaps in a connection or a nexus between the defendant and and specific aspects of the divorce file. What is your argument concerning it?
There are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion of limine concerning the testimony of Sarah Yusuf. Mr. Zellman.
Again, Your Honor, we stand on the motion.
Ms. Cobbin, response.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well,
So, hey Ken. So they don't want to talk about the divorce? Is that what that first motion in limine was about? That's part of the motive. Okay, I had to go to the bathroom. Somebody fill me in. I missed it.
and I assume you are going to leave Ms. Yusuf available as a rebuttal witness if necessary.
Yes.
If a witness is not going to be called, that essentially moots the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Yusuf still is able to testify in that capacity. The next motion of limine concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kaplan, response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points, so I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection, so I would ask that it be handled in that way.
Well, yes, because Veruca wants it her way and she wants it her way now.
Concerning the testimony of Mr. Webster in his capacity of representing the deceased certainly can testify factually as to what his involvement was with the divorce case and also, he may testify concerning the nature of the proceedings. As to any opinions that go beyond that, ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately, opinion that Mr. Webster cannot give without a proper foundation. I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markel. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule for
Statements made by the deceased to Mr. Webster. Ms. Cattleman, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markel to his attorney and offer my theory of admissibility prior to asking the question if I decide to do that in this trial. I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Very well. Again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased. If the state, again, will have to present an actual exception to hearsay in which the matter can be.
Well, like that emergency motion yesterday, the defense didn't want the subpoena to be quashed. They basically wanted the judge to decide on every question whether or not she was going to be permitted to answer it or not, which would have meant excusing the jury, discussing it outside of the jury's presence, and then bringing them back in and then answering the question. And doing that over and over and over again. And that's just not going to happen. So, yeah, Little Miss, both Donna and Wendi want to be coddled and get their own way. I hope they all go down. I really do. I hope when this is over and locked up and they got her, that then they go after Wendi. Because if she didn't have a part in it, she knew. She had to have known. She was going to drive by the house that morning. I guess that the next day, like the morning after. So, she was going to the store or somewhere. Yeah, she was going to a bachelorette party or a bridal shower or something, and instead of taking the main roads, main public, highways, the main roads through places where you go to the store, she turned into the neighborhood where he lived. And she's like, oh, it's just a habit. Once you go a certain way, that's the way you go from the. No, it's not.
Place before the jury. Right, the removed motion in limine concerning the Latin Kings.
We're going to hit the pause button right here. This next motion should get interesting. We'll watch it together live right after this quick break.
Acted
Do with mention of the Latin Kings gang. Let's listen.
Mr. Zellman.
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation laid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There would only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agent I believe it's Jimenez.
In the last trial, he outright testified that he was, I guess, at least pretending or trying to a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Kappelman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think, is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting the character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may bring up this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover agent, Ms. Kappelman, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just
There's two hitmen. There's two hitmen. There's Charlie's girlfriend, Charlie. Wendy's the fifth. No, Donna's the fifth. Wendi will be the sixth. If they get Wendi after Donna. So yeah, it was 6 people involved in this conspiracy. To kill one man that was doing nothing wrong but minding his own business.
An associate of this killer who is a gang member.
Any response on that topic, Mr. Zeldin?
Just looking at his previous testimony, my role, I'll quote from page 1067 of the trial transcript in Mr. Charlie Adelson's case, starting at line 20. Question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member, and I was instructed to conduct the bump. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay. So that's the role. That was my role. You're in character. That is correct. That is his testimony. And I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind and who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
All right. As to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his bump operation. Depending on what the answer is, we'll revisit the issue of whether the name Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin King, that is where the line is going to be drawn. Do we need any clarification on these rulings?
Just a moment, Your Honor.
Not from the state judge.
Okay, so the judge is giving them some latitude, saying, sure, you can ask him about his membership in the gang, his role regarding the undercover agent, but we're not going to get into specifics about the Latin Kings and his role in that gang. All right, Judge kind of split the baby there with that issue. Let's see what our legal analyst guest thinks of that. Attorney Rick Grundy watching along with us. Rick, what do you think? Right ruling with respect to...
I'm looking for some financial advice, and I went to Merrill Lynch.
If she is committing to do so as a part of her defense, that's her choice. But ultimately, someone with complication about state of mind from a witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning?
Okay, we need to stop and back the truck up just a moment here because there was something that came out. If you were listening really closely, I know you caught it. Like I did here, did you hear Donna Adelson's defense attorney when he was talking about how his client Donna became even more fearful when she was confronted by this person because she learned that Luis Rivera was a leader in the Latin gangs, and that made her even more fearful because of his high rank. And then the lawyer said, and she will testify to that. So we have no confirmation that she's going to testify, but you just heard him say that. I think that's a preview of what's to come, my friends. Now, of course, she can change her mind, up to the last second when the judge asks her if it's her wish to testify and advises her.
I don't. I agree with you that there's a far long
Case is set to go on August 19th. That is when they're going to start picking
emails, the recorded phone calls, and the text messages, other than coded language.
So, totally off topic. But I get this X notification, and it's J.K. Rowling. It says, "Speak up. I can't hear you over the din of 4 theme parks." So I'm thinking, oh, great. Is she pissed off at Disney now? Because Disney has 4 theme parks, So I'm like, is she boycotting theme? What is going on now? And why do we even need anybody's opinion about anything? Leave people alone. Let them do their own thing, right? She was replying to this. "What an awful, hateful witch you are. No wonder kids hate you now." So her response was, "Speak up. I can't hear you over the din of 4 theme parks." She's talking about the Harry Potter theme parks. Yeah, kids hate her. No. Kids love Harry Potter. And adults, too. Okay, sorry. I'm sorry. I thought this was like an actual hearing and not a court TV news blah, 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 blah. Yeah, I wasn't even thinking about 4 Harry Potter theme parks because I know I hate when this stupid thing pops out. This little, I don't know what it is. Go away. It's a Windows thing and it's got news on it and the stock markets and I don't care. It's 92 degrees here. Yay. Go away. I can't see my screen. Yeah, I didn't realize there were 4 because there's one in Florida. Well, actually, I wonder if she's counting. There's actually 3 in Florida now. Okay, yeah. She's counting the one in Florida as 3 different parks. Okay, that's why there's 4 now. Sorry. Squirrel. That was my squirrel for today. I haven't been to Epic Universe. I haven't been there yet, but I've seen videos. Yeah, it looks pretty amazing. It does. Islands of Adventure in Florida. So Universal has Diagon Alley. Islands of Adventure has Hogsmeade and Hogwarts. Epic Universe has Paris from the either the second or third Fantastic Beasts movie. It's got the circus, the Fantastic Beasts circus show, and then it has another area where it's the Ministry of Magic in London. So you go from 1930s Paris to like 90s London, and it looks exactly like the movie. And when you walk into the fireplace entrance, it looks like you're walking through green flames. It is beautiful. And then they have the Hollywood Universal one, and I'm not sure what all they have out there at that Universal. But yeah, that's 4. I was counting ours as 1. That's why I was like, how is there 4? But yeah, there's 4. There's 4 now. Yeah, and I've been to 2 of them because I haven't been to Epic Universe yet. But yeah, it aggravates me. But I've never been like copyright claimed or whatever from them. So I guess as long as I skip through them yapping that they don't care that I use it.
We're asking the court, because it has come out so frequently, the court prohibit the state, and what's good for the goose is good for an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Kappelman, response.
I agree, that would not be admissible.
The motion in limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court previously ruled on this issue and that allowed the state to use this information in their argument. The new information, as I laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping onto the jet plane.
If I'm recalling prior counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct, Your Honor.
Well, response, Ms. Kappelman.
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and ruled on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir. Well,
I believe that covers the defense motions. And And Ms. Cappleman, you stated that the state did not have any additional motion in limine that had not already been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Newland and Patrick Sanford.
Oh, yes. Go ahead as to that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Cappleman, response.
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Cappleman, even though it might be inquired into at deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course. There is no reason to elicit it at deposition, and then it could never be admissible at a trial. So we're just wasting paper and time with these motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by either Investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. I don't really see a context in which this might come around, either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, we'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19.
Okay, now they're moving on to jury selection. Let me get some quick thoughts here from our guest analyst, Attorney David Gelman, criminal defense attorney, now former prosecutor. David, good morning to you. That last little issue taken up, curious what you think about that. Defense counsel, it sounds like, asked for some opinions during depositions, which can be done in David, I'm so glad you're on the show today. Stand by, kindly, please. We're going to hit our first break of the hour. When we come for the murder of Danny Markel, is Donna Adelson?
She was feeling it. Coverage starts.
I'm Julie Grant. We're going to go back to Florida together. Back to Florida now we go. It's time to talk about the jury selection process for the trial that kicks off August 19th.
We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially, we will have the pre-screen of the jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there, they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue, or either the court believes, the state believes, or the defense believes, is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to what will be told to return or used at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are.
Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there For allegations the jurors were speaking to each other, we are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your Honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they're seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect. That's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
Defense would request 3, Your Honor.
Very well. And once we have our 12 jurors and 3 alternates, at that point we will swear them. If we have enough time to actually move into opening on that same day after the selection, we'll do that so that way we can start to begin into the witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7, so 6. I could see how it could run the first 7th day. I think 6 is a comfortable estimate.
All right, let me bring up my calendar. Assuming that we have a jury by Friday the 22nd, when we roll that in place, August 25th, it's case in chief. I think there is a holiday on September 1st, correct?
Yes, sir.
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I need one other hand, unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:02, when we're estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
Judge, we don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer your opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
right? On that matter, again,
I just love Judge Stephen Everett. You know, he is a great judge. He knows how to run the trial. He is sharp. He knows the rules of evidence. He probably knows the facts of this case. He can cite him off the top of his head. He sort of, how considerate he's being of these lawyers. I have to think, asking them what their preferences are for the opening statements. Really, really considerate.
Hey, yeah, it's good, and also
I don't have any answer about a cream, and I don't have a Band-Aid. Borrowing sanitary pads. She said,
now.
Coming on the time-wise, I'll just instruct both parties to give their openings. I'm not going to place a time limit on the opening statements. Party will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Cattleman.
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Well, as to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. All right, concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do the parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
All right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday with needing to select a jury.
Okay. If we get a jury...
If we get a jury prior to that Friday on, say, the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
Okay, so I'll be prepared to start testimony on the 22nd then, and my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here. The parties have any matters of logistics they need to raise concerning the trial.
Yeah, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
right,
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And
Press and hold.
Right, press and hold. You got to hold it down for it to continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, but in front of the jury, I definitely understand the concern that you're registering with this. What requires that what can be done for the microphone on the table. If your client though does need to write things down, so that way nothing is being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first two rows behind the defense, those are not going to be available to any members of the media. As far as the font size on your computer, if you need to rearrange how you're seated at the table, so if you need to seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it. I don't really know what I can accommodate you with as far as that font size beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
When I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this need.
Right. Please make a request there in the court, and then we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, and I believe the state is going to try to, or needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how that will need to be set up, the tables and how they're configured can't interfere with that, but we'll try to accommodate that as best as possible. Ms. Kappelman, as to the audio or visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir. It'll be the same setup with the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place.
Okay, now let's pause things here and talk about this concern, the concern of people who shouldn't be hearing the legal matters discussed and the defense discussed at counsel table because of positioning of monitors and microphones. That is
you're really going to be looking for. So I think this is much ado.
Our next segment, we're going to break down what it's going to.
The ship is really sinking fast.
Testimony coming up for you in our next hour of programming.
And then I assume the victim's family is wishing to appear.
Yes, Your Honor.
All right. They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does either party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming to support her as well. And we would request that they have similar priority seating as the victim's family.
That's what the 2 rows will be behind the defense that will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated, but ultimately what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
No, Your Honor. One last thing. Typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified to the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
No, Your Honor.
One other matter comes to mind if the attorneys can briefly approach.
Quite as informative as I had hoped. That said 9 days ago. This is 11 days ago, and it's law and crime. I wonder if this is the same thing, but without interruptions, which is probably what I should do.
And which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with as identified.
Inadmissible, it's irrelevant. Paragraph 7 of my motion provides.
Jackie Fulton for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage.
This is the one we just watched. This is the one we should have watched. We wouldn't have been interrupted 1,500 times. I know there's another one. Oh. I don't think we've seen this one.
All right, we're here this morning on State versus Adelson, 2023 CF 3226, the defense's motion to change the venue of the trial. Parties may make their appearances.
Georgia Kappelman for the state.
Sir Catherine Dugan for the state. Jackie Fulford on behalf of Mrs. Adelson.
Joshua Zellman on behalf of Mrs. Adelson.
And I will note the defendant is present in the courtroom for the evidentiary hearing as well. Before we get started with taking of the testimony of the witness, Mr. Murphy, I believe he's going to be the only witness for the defense today. Is that correct?
That's correct, Your Honor.
All right. In reviewing the motion, the affidavits in support, and also the memorandum of law, I wanted to make sure the state had not filed a formal response. You were planning to make your argument today. Is that correct?
That's correct, Your Honor.
Very well. As to the affidavits in support, Mr. Zellman in particular, I saw that you had placed an affidavit concerning this matter, specifically for the court to consider this as it goes to both being advocate and witness in the same matter. How exactly is that to take place?
Your Honor, the rule requires an affidavit of 3 individuals, one being the defendant and 2 other individuals. It does not identify who they are, and also does not require that those individuals testify.
Again, you are the primary counsel for your client, correct?
Yes, Your Honor.
So as to your legal arguments and also your factual affidavit in support of, you believe the court can properly take notice of both?
Yes, Your Honor.
Does the state have any argument concerning those?
No, sir.
Very well. As to whether there's any issue with the court accepting that as evidence, I will conduct my own research, but we will move forward at this point. I do see Mr. Murphy is already in the Zoom. Mr. Murphy, good morning, sir. I think you're muted right now.
I only do this 10 times a day. Good morning, Your Honor. My apologies.
Good morning. Good to see you. The technology helps it be more convenient, but at the same time, well, at least you're not like the lawyer who was, I believe, on the Zoom saying I'm not a cat.
The morning is young, so I'll try to avoid that.
We're doing much better in that regard. All right, I believe previously in preparing for the hearing today, the time allotted was going to be 2 hours to the defense to make their presentation. The state would have a half hour to respond. I will go ahead and swear in Mr. Murphy, and the defense's time will begin at that point. Mr. Murphy, please raise your right hand to be sworn, sir. Do you swear or affirm the testimony you're about to give today as a part of this proceeding will be the truth?
Yes, I do.
You may lower your hand. Mr. Zellman, you may examine the witness when you are ready.
Thank you, Your Honor. I have a number of exhibits that we discussed the other day on a flash drive. May I approach with that?
You may. This is a newer version of this binder?
Some of the information has been updated, yes, Your Honor.
All right. Is there any objection from the state as to the court considering this as admitted evidence for the defense for the hearing?
No, Your Honor.
The jump drive will be defense 1. You may continue.
So the way that I have the drive organized, Your Honor, there are 6 folders. Exhibit 1, Exhibit 2, and Exhibit 3 are materials from TrueScope. Can I have permission to share my screen so that Mr. Murphy can?
You may.
So the Exhibit 1 is TrueScope's raw data that we had previously submitted. Exhibit 2 is the original report from TrueScope, and Exhibit 3 is the updated report that was finalized. We'll be going through those, and just by way of a brief opening, Your Honor, if I may.
Go ahead.
It goes without saying that the 6th and 14th Amendments to the United States Constitution, as well as Article 1, Sections 9, 16, and 22 of the Florida Constitution, guarantee an accused a fair trial by an impartial jury. With that, Your Honor, I guess you've already sworn Mr. Murphy. Mr. Murphy, can you please introduce yourself to the court?
Yes, my full name is James Todd Murphy. I'm president of TrueScope in North America, media intelligence and analysis service.
And what is media intelligence and analysis?
Media intelligence is the overall term given to our industry that includes media monitoring, media analysis. It's kind of two components to the single industry. Media monitoring is the action of tracking and indexing and reporting media across or stories from media of all types. And then media analysis, sometimes called insights, is the analysis of that data, looking at both qualitative and quantitative information using a framework that is that can repeat valid results.
How does TrueScope gather that media?
We have two primary, or I would say two different methods. One is we use aggregators that pool content. So for like the broadcast data, we have a party that records all designated market areas, or those, it would be simpler to think of those as cities. There's 210 city markets in the United States that are monitored. For example, New York City is number one, and it's based on the size of the market area. So for TV and radio, we aggregate all that, and it comes to us in a feed that has metadata attached, so we know the date, time, station, and then the video is indexed to a timestamp. We do the same thing with radio, podcasts. On the print side, we actually scan much of that, although we do receive feeds from partners of scanned and indexed data. Those generally are sent to us directly from the publishers as PDF images with the text layer behind it. So there's really no break in the chain coming from them for their printed media. We do the same thing with magazines. Social media, it's more of a feed from each social network. Facebook has a feed, Instagram has a feed, LinkedIn, etc. Online news, we use a system where a crawler crawls the web, pulls back anything that has changed, that then gets put into a feed. And these feeds all come into us via an API, which is basically just a conduit for communication. All that comes into our server or servers that are hosted on Amazon, where that data is then processed into topics, and additional supplemental, they call it metadata, additional data is added to that. Who's named in here, what industries are mentioned, and all of that then is indexed so we can run queries against that and report just specific topics. So if Judge Everett wanted a report each morning, for example, of anybody talking about him, he would get, at whatever specified time, a report of all media, or if there's no media today, he would get a report saying there's no news about you. That's the media monitoring side. The media analysis side then takes all that data that we've captured for a specific topic, and we run some automated systems against that to generate media dashboards, charts, graphs. That's mostly for the quantitative side. Once the quantitative side has been developed, then we apply a methodology for the qualitative analysis. and stop me if I'm going too deep for this question.
No, this is perfect. Please continue.
Okay, so once we have the quantitative, we create the qualitative frame, using the methodology within our framework for the qualitative data, and that's currently based on the Barcelona principles, Barcelona 3.0 principles, as set out by the Global Measurement Association, trade association called AMEC, A-M-E-C. So we use the AMEC principles to make sure that we're using best practices in evaluating the media that we've monitored.
Now, let's talk a little bit about your background and training. Can you tell the court about your background in media intelligence and analysis, please?
Without sounding, I guess maybe too folksy, my family has been in the industry since before I was born. My father purchased a press clipping service, as they were called, in the late 50s. I began broadcast monitoring when I was 15. He wanted to add the TV and radio side, so I technically set that up for him. And graduated from college in 1991, began full-time, and then developed additional services like competitive media analysis, qualitative media analysis, and others.
You said you graduated from college. What is your degree in?
I got a degree in radio, television, and film, and a minor in psychology.
Beginning in 1991, can you advise the court exactly what it was that you developed through the company? It wasn't called TrueScope back then, was it?
No, it was, initially it was called Universal Press Clipping Bureau, founded in 1908. In 1998, I changed the company name to Universal Information Services, and then in January of 2023, I merged the company with a technology firm out of Australia by the name of TrueScope, taking on the name TrueScope in that month.
Can you tell the court a little bit about your qualifications?
Yeah, there was a lawyer on Zoom court that his kid or nephew or niece or somebody had been messing with the settings on Zoom, and he showed up in court with a cat filter on his Zoom, and he didn't know how to take it off. So he looked like a cat, and he was like, "I'm sorry, Your Honor, I'm not a cat." It's so funny. And he had no idea how to turn it off.
In the field of media intelligence and media analysis.
Sure. As you might imagine,
It's about allowing media in the courtroom. They do this before every trial now.
a person who is born into it and grows up from a young age in it. I've held all the leadership roles in all of our trade associations, which includes IABM, which was the International Association of Broadcast Monitors, NDS, which was the News Data Services Cooperative, the NACPCS, National, it's press clipping. It was an early press clipping conference. I can't remember the exact acronym right now, but it was a North American Conference of Press Clipping Services. There we go. My apologies, Your Honor. Let's see, after that, became a member of AMEC to add the measurement side, and I've held North American leadership roles there, and currently am president of FEBEC, which is the global trade association over all MMO, the entire media monitoring organization industry, which constitutes both both media monitoring and media analysis companies.
Now, in addition to that, have you yourself also developed software that is now used in the industry?
Yeah, in the 90s, I had two primary developments. One, in 1995, developed the methodology for comparative media analysis, which was transparent, allowed you to see all the data behind the figures and the inferences, and allowed you to compare one entity against another. In the commercial realm, it might be a market, say Chicago, for example, that has a multitude of healthcare systems. It would allow one healthcare system to track how they're performing, both in terms of volume of media mentions, impact, reach, and then the qualitative side, primary message points where they either are leading or trailing their competitors. I also developed the first software and database and hardware solution that would allow you to track multiple TV stations. The closed captioning that's embedded in broadcast programming, I had a program written where I could extract multiple channels, 4 channels simultaneously, all to a single database and that was the first instance of indexing broadcast media, which has come in handy when people try to trademark and patent that process. Having that prior art has helped me.
Have you previously testified as an expert in media intelligence and analysis?
I have.
Approximately how many times?
I think this will be my 5th formal testimony. We've done consulting for attorneys all along where they say,
Okay, maybe I'm not following this like I thought I was. They were talking about media in the courtroom. The one chick lawyer, her Donna Adelson's lawyer, was saying she was old. She had to make the font on her computer bigger, so she didn't want any, like now, any cameras showing her laptop, showing her computer, because you would be able to read the font on it. And they both talk loud, and if they're talking to their client, everybody would be able to hear it. No, just hit the off button on your microphone, stupid. So why are they now asking this guy if he's testified in court before? I thought he was an attorney for, I guess, Court TV or Law and Crime or something that's wanting to broadcast this. Now I'm lost too, Judy.
to receive the data, but in terms of testimony similar to this would be my 5th time. Probably an equal number of our data plus an affidavit have been sufficient. If that's suffices for your answer.
Thank you. Your Honor, we would tender the witness as an expert in media intelligence and analysis.
The state wished to voir the witness.
No, Your Honor.
Oh, just for
Court at
him
this
to
time
talk
will
about
permit
this?
the witness to testify in the form of an opinion during this hearing as to the specific topics. I believe it was media analysis and what was the other?
Intelligence.
And media intelligence. You may continue.
Thank you.
I'm
now,
lost.
In the field of media intelligence and media analysis, in addition to gathering this data, you also have to quantify that, and that requires math, correct?
Correct.
And the mathematical principles that you use are generally accepted in the field of media intelligence and media analysis, correct?
Yeah, that is correct.
And in addition to the math concerning that issue, is it also generally accepted in your field to use similar mathematical principles to identify how many times somebody would have to see something in order to form a memory, and there's a standard.
Oh, okay. I know what's going on. This is a change of venue hearing. So they're trying to prove that because of the news and whatever else in the area, they can't find a jury here. This is from, because remember now, guys, we're watching old hearings. This is from 2 months ago. So obviously it was denied. But they tried it.
Formula for that we're going to go over, correct?
That is correct.
Now, on a factual level, how closely have you followed the murder of Dan Markel in the state of Florida versus Donna Adelson?
I have not followed it at all. Personally, as a standard operating procedure, I tend to avoid news such as that on the principle that we may have a client that we serve in this capacity. Certainly once engaged by a client to evaluate a specific case, I will call it, I tune out completely and avoid all media related to it. Just on the outside chance, I might see something that subconsciously would influence my opinion. Now, anytime you frame something, for example, you're looking at me right now and you're forming an opinion about how I look, that's the principle I apply. If I were to see a television news story, it's through the lens of a reporter. Even if it's an unbiased story or what we might call a balanced story, it's still framed, and what's in the frame, or what they might call the mise en scène, things in the frame can also influence. So as a person in my capacity, I avoid specifics related to a case we have, if not before.
Now, how has TrueScope collected the data in this case?
So in this case, all of the data has been gathered through our standard operating procedure through our aggregate systems, transmitted via API calls into our servers for indexing, processing. The text is never modified. The data that we receive from the media outlet is never modified. It's simply categorized and basically labeled so it can be recalled and have additional information telling us who, what, where, when, why, what time, that type of information.
And
that, go ahead.
No, please.
And then that information for a client or a case such as this is analyzed and managed by my media analysis team under the direction of Cheryl Lewis.
And the way in which the data was gathered in this case followed the generally accepted methodology in your field?
Yes. So one of the things, we have two layers of check and balances above each of our departments. Jean Saucier, who oversees, she's my senior vice president, oversees that department. She checks to make sure that progress towards a timeline is being made, but also that each step in the process is followed. Within the media measurement team, they have two people, and they have a rule that two sets of eyes look at everything. So anytime a spreadsheet is created, the assistant media analysis person on this job would review it, trying to find any errors in the data. And then lastly, which I think you've been a part of, Mr. Zellman, is I review all the data with the team, and I ask for additional things that I want to see. It could be volume of mentions over time or something else. So I don't look at the data prior to the nearly final reports, and then I say, okay, is there something missing in this situation? And ask for them to produce that.
Now, in doing so, you talked about a spreadsheet earlier. TrueScope prepared a spreadsheet of the raw data in this case, correct?
Yes.
Is the spreadsheet that is on the screen the raw data that TrueScope collected?
That is our data.
Okay. Now, there are a number of tabs. What is the purpose of having these different tabs at the bottom?
The different tabs, generally speaking, or simply put, correlate to what queries resulted in the data found. So, for example, this first tab that you're currently showing would be a query for either Donna Adelson or Charlie Adelson. Potentially would include any variations on their name that would then be reviewed to make sure it's the correct Charlie or Donna Adelson. Each row on the spreadsheet then represents a single article or story or unit of reporting, whether it's a TV story or a website article. Moving across the row, you're going to see all the metadata that is included with each story.
And can you tell the court how many articles, and this appears to be newspapers?
Yes.
How many different mentions were found? What was the time period that TrueScope was searching?
So we looked at a couple of different slices. Some of it came back further than others to do some comparative analysis, I know. But overall, I believe we went as far back as 2014 to 2025 for some of the data. And then we also did a June 2023 to May 2024 sample analysis.
And so
I'm not sure that answered your question directly, though. This tab indicates there were 233 mentions of Donna or Charlie Adelson during that time period, correct? That is exactly correct. 233 rows, but the first row would be headers. That would be another query, a new query, that's not looking specifically for either Donna or Charlie Adelson, but additional names associated with this case that you or the client would ask us to look at either for comparison purposes or whatever they need. We generally don't offer legal advice on what you need for your situation, but the advice we give is how we've done this in the past and our expertise in doing it in the past, and we would suggest, are there additional people involved in a subject that should also be queried to see how many stories mentioned them and in what relation to the overall subject you're most interested in.
So with respect to this tab, the searches were done for the alleged co-defendants or co-conspirators, McDaniel, Garcia, or Rivera, correct?
Correct, and although we just have last names listed, again, we would have ensured that we were using first names and variations that correlate directly to those individuals.
And for this tab, there were 308 mentions of those of the alleged co-conspirators, correct?
That is correct.
What is this next tab?
That's going to be a more of a, I call it a specific media type analysis. So it's a media type within a specific name query. So in this case, we were looking at queries of Dan Markel, a search term of Dan Markel, in both broadcast and some web content.
Okay, now the dates in the first column, the formatting is a little off, but what does that represent?
That would be the date. That would be the date of broadcast. So in that first, or what is designated as row 2, that story aired on January 8th, 2014 at 5:34 p.m.
Was it January or was it August?
Oh, thank you. Because our technology is built in Australia, our dates are day, month, year, as opposed to month, day, year, as is more commonly used in the United States. we provide the service on a global scale, so even I have to remember that. My apologies.
Now, in this tab of information, does this include closed captioning from television newscasts or broadcasts?
It does. That's correct. So that's text inputted or live captioned by the broadcasting station or network.
And this also, and can you tell the court how many mentions there were, how many articles or broadcasts?
2,818.
And then what does this next tab represent?
So this is going to be what we call internally the roll-up of the quantitative data related to different views. So in this case, we're looking at cities or potential designated market areas. We include what county they reside in, that amount that each of those cities and or counties, how much the volume of media mentions, so that would be the number of stories or articles or web pages within that geographic area. Column D would indicate the total audience. People may be more familiar with the Nielsen ratings. That's where those audience figures come from. Sometimes you'll see them referred to as impressions. That often is a more generic term that can apply to other media types. But in terms of broadcast, that would be the Nielsen audience rating based on their methodology and their standard for establishing how many people had an opportunity to view that story in a specific geographic region.
And so, would it be accurate to say that your team looked at the total amount of articles and broadcasts that were identified in the previous tabs and then sorted them based on market area?
That is correct.
And the total number of broadcasts or articles that were published and TrueScope was able to collect, what was the total for Leon County?
3,371.
County from?
That would be from the most recent census numbers from the government. So that's the obviously census.gov data to pull the most accurate count as each census is updated.
And can you explain to the court what an opportunity or to be seen or impressions per person represents?
Sure. So whether it's the tabulated audience or unique visitors to a website, each media type has their own type of audience count calculation or impressions. Since the simple math takes the total number of stories and then divides that into the population of an area that we're looking at. So you take column C and column E and you can come up with, including column D, you can come up with a calculation just on basic math, where on average, an individual residing in that geographic area would have X number of opportunities to see this specific story, whether it's hurricanes or a story about a hurricane or the subjects within this case.
Before you continue, Mr. Zellman, I do have a question on that point. Mr. Murphy, is the opportunity to be seen the same thing as definitive proof of engaging with that particular content?
It can't be, engagement can't be measured in what I call the passive mediums. That's going to be television, radio, because you might turn on a radio station in your car and listen to the news on your way to work, but I can't say that you necessarily engage with every story. You may be a sports person and you're just waiting for them to get through the weather. So opportunities to be seen is I'll call it a more objective label to put on it when the media is passive. When it's an active medium like social media, we do have the ability to calculate engagements, like if you liked it, if you shared it, if you commented. So we do use the more objective opportunities to be seen to calculate the potential of an average adult or jury eligible individual within that geographic area to see a story.
Please continue.
Thank you, Your Honor. Now, you conducting this analysis for Leon County, did you look at other counties in Florida?
We did.
And we're going to go through that in the next exhibit in more detail. I'm now going to pull up Exhibit 2. Is Exhibit 2 on your screen?
It is.
Can you tell the court what this exhibit represents?
This is going to be the output, but it undoubtedly goes through several revisions until it passes all of our checks and balances, but this is a annotate specific interpretations or inferences from the data to indicate to our client what a chart or graph or image might be showing in terms of their analysis on that page.
Now let's go to that first slide. What does this first slide represent?
It's very small on my screen. One moment. So that would be similar to what we saw on the previous exhibit. This is the media coverage for nearly an 11-year period by county, from designated counties in Florida.
And what counties, so Leon County, this is the 376 opportunities to be seen or potential impressions that we discussed previously. What other counties did you focus on, and we'll get to that next exhibit, but with respect to Miami-Dade County, what were the number of opportunities to be seen for residents, adults in Miami-Dade County?
2.
Wait a minute. Wait, whoa.
What does this represent?
She wanted it moved back to Dade County. No, you cannot go back home. You'll try to escape. You think that that's why she wanted it moved back to Dade County? Wyoming? That's not a usual place for earthquakes, is it?
That's the volume of media coverage by media type. Excuse me. This is where we simply break down the overall media coverage that we're analyzing for the client to see which media types were most predominant. This often comes into consideration when I'm looking at active versus passive media types. It can also be used to make inferences based on journalistic credibility versus media reporting. Just to elaborate, believe it or not, despite what we often see in political rhetoric, there are journalistic standards that professional journalists try to adhere to when reporting, as opposed to a person who might be creating media. A talk show, more of an opinion-based show, can have some greater latitude than a journalist might take with a story. But in this case, you can see TV news was the predominant, by far the predominant media type, followed by print media with web and radio turned on.
What is the purpose of this next slide, slide 4?
That is what I call more of a control analysis, a simple control analysis to look at what would an average news story in the same area generate in terms of, say, impressions or
What just happened?
going to decay. Invariably, what it's going to show you is the attention, and the judge previously asked about engagement.
Where'd it
There's a
go?
certain level of desensitization to the stories that are most common: car crashes, fires, things that we commonly see every day on the news. But we like to often look at what a average or common story statistically looks like compared to the story we're looking at for our client.
And so with this car crash story, I'm sorry, let me go back. How many opportunities have you seen or impressions? Hold on, trying to get the right slide. Did you calculate for the average story?
But I'm having a hard time reading that. It's going to be the number of stories divided by the population, but I can't quite read it. I don't want to confirm what you're all seeing versus what I'm seeing.
Let me see if I can zoom
in. It's like trying to pass the...
Your Honor, I failed the vision test. I was just kidding. That's not true. For the record.
They're getting a little bit bigger, Mr. Zell.
Yeah.
Is that better?
Yes. Right, so this is going to demonstrate that this average story appeared in the media about the car crash. Let's see, six stories were reported on that topic, generating just over 935,000 opportunities to be seen. And I'm just reading at the bottom, the story appeared over a 3-day span in a population of nearly 160,000 residents based on census data. And then we apply, I believe in Florida or in your county, the jury eligible age is 18, and so we calculate only those over that age in our viewing population.
And so with that calculation, the jury eligible residents had 6 opportunities to see one of these stories based on...
That's correct.
And finally, with this exhibit, hold on, let's see. This exhibit, what is the total number of juror-eligible individuals according to census data in Miami-Dade County?
There's over 2 million in Miami-Dade.
Versus how many in Leon County?
Just under 160,000.
Before you continue, when you say census data, this is the 2020 census number that you're using as a part of
it? It would be the most recent census data.
Please continue.
I'm going to pull up exhibit 3. I'll try to make it bigger for you. What does this exhibit represent?
So this is a timeline of media coverage, a quantitative count of stories over time. This is generally helpful in seeing the peaks and valleys. We can also easily interpret the decay of a story. So moving from left to right, in 2014 we see there's an additional starting point of the data, which then decays over the year to a low in 2015, and then spikes again during the year of 2016. Oftentimes you can correlate those spikes to activity around the subject. In a case like this, it can be arrests, allegations, people being named, court hearings, but the spikes almost invariably will always indicate some activity around the specific topic. And then on the right side, you can see between the years of 2021 and 2025, a more rounded but increasing volume of media coverage on this topic, which would indicate there are more things happening of interest to the media, and a slower decay where follow-up stories are occurring during that date range.
What does this next slide represent?
That's going to represent the impressions of the media. I'm sorry, the impressions the media are generating for that same time period. The scales are going to be different, so the peaks are still there, and so you can see the 2016 and the 2019 peaks, and then you also see that kind of 2021 things start moving up, and then that more rounded curve from the prior slide, you can see how it's represented by the impressions of the media covering that subject. How many people it's potentially reaching.
Okay, and according to the analysis that TrueScope has conducted, can you tell the court what 2025 is 2025 projected to be higher or lower than 2024?
Yes. Impressions from media coverage for 2025 are on track at this point to surpass 2024.
And what do we have here in slide 4?
So this would be another control comparison. Impressions of volume of coverage to another recent change of venue hearing or case based on what data is currently publicly available. So it indicates media exposure within Idaho compared to Florida. And what it is specifically is a heat map of each state showing the density of media coverage in various counties.
And with and so this is the what time frame was this analysis done, Darren?
This was just a 1 year sample where we had overlapping data collected. Since we also did this work, this is overlapping data using the same methodology and framework from a case in Idaho, where we also had the same type of overlapping data from the Florida case.
What is represented in this slide?
That's going to be the same date range comparing two counties in Florida. The blue line would be volume of stories in Leon County versus volume of stories in Miami-Dade.
And how many, what was the volume of story, and again, it's that same 1 year time frame, June of 23 to May of 24, what's the volume of stories in Leon County?
283.
And what was the volume of stories in Miami-Dade County?
It was about exactly 60 less, 223.
What does this next slide represent?
It's going to be similar date range and county comparison, but showing the impressions, the total tally of audience. And it's showing that in blue, Leon County had more impressions within that geographic area versus the number of impressions in the Miami-Dade geographic area.
What does this next slide represent?
Again, this is going to be a media type donut graph of volume of coverage by media type, which is going to indicate for me passive and active media, but also to anyone who's viewing it reveals which media was more engaged or reported more frequently on this topic.
I'm going to go back. Now, over the lifespan of this investigation, July of 2014 to present, based on your analysis, do you have an opinion on how the span of time has impacted the media coverage in the case?
Yeah, I can certainly provide my opinion. In my experience, it shows a topic of interest to the media where the story has what, has, you may have heard the phrase, the story has legs. It has captured the interest of the media over time. Some stories, such as a car crash, at this point in time, it would be nearly impossible to find anyone in the county where a car crash occurred that can remember any details of that story. This is indicating repetition over time and volume of impressions are over time are high. So what I would start thinking is I expect to see in the numbers a higher level of retention based on saturation of an average citizen in a geographic area. So this is, in my work, this is what I start looking at and building what my expectation should be coming in the downstream data. And if I don't see it, then I have a rerun to see if we made a mistake anywhere, or if there's a contributing factor to why a story stopped. But this is to summarize, this is a very typical shape and volume of impressions for a story that captures the interest of the media over time at a high level, too.
And so I think that's a good segue into the math of memory that we discussed earlier. Can you explain to the court the concept of math of memory?
I hope everyone's had their coffee. So the math of memory is a basic probability theory that also uses a level of algebra, and it shows the ability to retain information, or inversely, how rapidly your memory of an incident or a story, in this case, decays over time. Ultimately, this formula is going to it shows, it's proven, and it's a globally accepted theory, that it has repeatable and valid results. The more a person is estimated to be exposed to a story, the longer they'll retain up to 80% of the details of the story.
The person we're referring to was someone of average intellect with no defects.
Right. Again, it's when we say jury eligible population, that doesn't account for anyone who might be exempted for a reason other than age.
Please continue.
So how does the math of memory, and I'm sorry, Mr. Murphy, were you done with the initial explanation of the concept of math of memory?
Yes.
Okay. And so how does, when you have number of impressions and opportunities to be seen, how does that factor into the ability of somebody to retain that information?
In my mind, it's fascinating how logarithmically your potential to retain information goes up once you surpass seeing the story just a couple times. So what we do is we apply the number of, so we take the total number of media mentions or articles or stories, the coverage, divided into the jury eligible pool to derive the total number of opportunities for this story to be seen by a jury eligible person in that county. Then we can put that number into this formula and estimate, statistically I might say, I need to preface that, but statistically, how long the average person of average intellect could retain up to 80% of detail on the story. How many, in terms of years.
Okay, and based on training experience, and when somebody has 376 opportunities to see an article or broadcast or podcast, how long do they retain that information?
If it's 336 exposures, I can't even estimate. I'd have to run the math again. I can tell you, for example, if a person's exposed once, that retention to interpret the story would be 3.3 minutes. And I've provided, I think you have that chart up as I provided it. You can see how it extends once you get up above 10. Statistically, it exceeds the lifetime of a human.
So, breaking this down, with the opportunities to be seen that we have in this case, for an individual jury eligible of average intellect, they're going to be able to retain that information for their entire life.
Yes. And that's based on the resultant figure that in Leon County, the average jury eligible person was exposed 26 times.
Just a moment, Your Honor.
Go ahead.
Now, Mr. Murphy, going back to the data that you were able to collect, you had mentioned earlier that TrueScope has the ability to collect and analyze podcast information and social media. Were you able to do that in this case?
To my knowledge, no. We were not able to include podcasts specifically in this analysis.
And why, can you tell the court why that is?
There's two functional reasons. One, having access to the podcasts and retaining that data, we need to have a client engaged. If we don't have a client engaged, we're generally, when we engage a client, we're tracking and going forward in most cases. With some media types, we retain that content and we can do back searching. In the case of podcasts, it's a newer medium. We don't have the ability to do back searching into the same time frame with podcasts. So I think that was at least one reason why we excluded it from the data.
And what about social media? Were you able to include looking backwards at social media?
Similar situation. Social media requires that we register topics. That's an internal phrase where we, in a sense, put the topic into the social network of, say, Instagram, for example, so that it can return results related to that topic through the API that connects us. Since we didn't have engagement with your law firm in 2011, none of that had been registered, so we statistically excluded that media type. One reason. That would be my primary reason.
Just a moment, Your Honor. Mr. Murphy, since TrueScope was not able, TrueScope in this case was retained in January 2025, correct?
Correct.
And so what you're saying about the social media and podcasts is because you weren't retained, you weren't able to go back in time to collect the data from social media and podcasts.
That is correct.
If you had been able to obtain that information, do you have, are you able to offer an opinion as to how that would have impacted your conclusions about total number of potential impressions, or as the court was asking earlier about active engagement?
Yeah, so there's a couple specific, I would say, factual opinions I can share. One, neither of those media types are able to be geographically pinned down. A podcast can occur anywhere but be specific to another region, so it makes assigning it to a geographic region nearly impossible in most cases. So that's one reason. And I apologize. Can you repeat the question, because I got too deep into my first answer.
So I was asking how, if you could offer any conclusions as to how, if you'd been able to obtain that information, how it would factor into your ultimate conclusions.
So the geographic issue is one. What it would have done is it would have simply increased the volume across the board. It would have been treated more like national media exposure. And let's just use a simple number of 100, let's say. If there were 100 podcasts, it has equal potential to be seen in any of these counties or heard, as the case may be. And social media is the same way. It would have an equal opportunity to be seen in any county, not in Florida, but globally. So statistically, it would simply increase the values across the board by the same number. You would apply an N factor to it, and it wouldn't change the charting of impact or opportunities to be seen. It would increase the opportunities to be seen in each county, but by an equal amount. So the outcome would change, if that makes sense. And I can rephrase that if it was confusing.
I understood what you meant. I don't know if the judge would like a different explanation.
Make it as simple as possible.
The water would rise equally in every county, and so it would provide no one an additional bump or decrease over another. It would just be a wash.
So in other words, if you had been able to factor in data from podcasts and social media, the numbers, whatever that number is, would have applied equally for Leon County and Miami-Dade County.
Right. It wouldn't change the outcome of the analysis. It would simply increase the numbers for all of them equally.
Nothing further, Your Honor.
Cross-examination. Does that microphone work?
I think so, Judge.
I can hear
Mr. Murphy, can you explain your fee schedule associated with your work on this case?
I would have to check with my accounting. Our CFO would have that detail. We generally, I can speak generally to our fee schedule. There's a monthly subscription cost for us to monitor the data. And then in addition to that, if a client takes the opportunity to have us analyze their data, there's an additional fee for media analysis. So in this case, there would be two components, the media monitoring and the media analysis. And then on top of that, if myself or one of our team members is asked to provide testimony like this, there's an additional fee for my time or Cheryl's time.
Okay, can you give us a ballpark for what the cost would be for work that what you've done so far in this case?
Sure. A normal subscription to a monthly subscription of this type, and if I'm charging the client more, I hope that's not the case, but it generally runs around $1,500 a month for media monitoring. Analysis can often add another $1,000 or $1,500 a month to that cost. And then my fee, if I'm in person on site, it includes travel expenses, and then if it's just a one-day engagement, $10,000. If it's a virtual situation like this, my fee's $4,000.
Okay. Do you know how many potential jurors have actually viewed content related to this case?
No one can know that number for certain. So I think what we're looking at is possibility. Your question revolves around possibility versus probability. We're working with probability and statistics. When you want to say, I'm sorry, I answered your question. I won't go further until you ask me.
So the answer is no, we don't know how many potential jurors have actually viewed. We're basing it on averages and probabilities.
Correct.
Okay. And so is there a way that we could find out if an individual potential juror had viewed content related to this case?
I believe that's part of what would be done in the jury selection.
And could we also ask the juror, how long did you view the item? How much of it did you retain? Questions like that could be asked at jury selection. Is that right?
Yeah, any questions could be asked. Then we get into the psychology, the behavioral psychology side from my perspective. What's the probability? And in my case, I'll only be speaking to probability because space jump can fall on the courthouse and change everything. So I don't deal in possibilities. But the probability is what we presented in the numbers. I'll leave it at that.
Okay. Do you have any data or probabilities about what percentage of potential
could
jurors
fall
have
on
formed
the
a fixed or definite
courthouse?
opinion about the guilt or innocence of
What?
this defendant?
That's a complex question, which I do not have.
In your affidavit that you provided to the court in this case, 3 prior hearings were cited. I know you said 4 previous hearings you testified in, I think. Is that right?
Including this one.
Okay. So 3 prior, and how many of those hearings was the change of venue granted?
In the 2 earliest ones, those, I believe, one was moved from Sarpy County to Douglas County. That was in the 90s, I believe. It has impacted, I'll call it the boyfriend-girlfriend murder. I think, I believe the evidence was overwhelming and a deal was made before it went to trial or something. So I had to look back on that. In the most recent case, which is just about 10 months ago, that venue was changed.
So in the Catenacci murder cited in paragraph 14 of the defendant's motion, that case resulted in a plea, right?
That's my recollection. I don't have that information in front of me at this point.
So that venue motion was not ruled upon because case resolved. Does that sound right?
That's my recollection.
Okay, and in Nebraska v. Christopher Edwards cited in paragraph 15 of the defendant's motion, that motion for venue change was actually denied. Isn't that correct?
That is correct.
Okay, and so we're just dealing with the Idaho case. Is that the case that we're probably all familiar with, where 4 college students were slain back in 2022, I think?
Yeah, that's the most recent one. But there's a little bit of an apples to oranges. In the one where the venue wasn't changed, I was only asked to present on a report of media coverage. It wasn't a statistical analysis like this at this depth.
Okay, and in the Idaho case where the venue was changed, is that the same jurisdiction that's mentioned in your data compared to the data you prepared in our case?
I apologize, I don't understand the question.
When we see the map of Idaho in the exhibits that we just reviewed, is that referring to that case that occurred in Moscow, Idaho at the University of Idaho?
That is correct.
Okay, and in that case, the judge did change the venue to Boise, correct?
Correct, Ada County.
And would you agree that the population in that county of Idaho where the case occurred was significantly smaller than the population we have here in Tallahassee?
That is correct.
Okay, and in fact, in the motion that the court granted the venue change in that case, the court cited insufficient space in the courthouse, insufficient staff, and insufficient security.
One moment.
May I finish my question before there's an objection, Judge?
Please finish your question.
In that case, isn't it true that the judge, in granting the motion for the venue change, cited insufficient space in the courthouse, insufficient staff, and insufficient security, aka deputies, to accommodate the trial of that case?
What is your objection?
Outside the scope.
It's in his affidavit,
His
Judge.
testimony has been concerning his work in Idaho, is it not?
Yes, Your Honor, but we did not get into whether or not the venue motion in that case had been granted or the reasons for that in his testimony or in his affidavit.
As to the subject matter, I will permit the question. If you are capable of answering the question, Mr. Murphy, please do so if you have knowledge.
I can only answer to the portion I have knowledge on, and I believe it was cited that the testimony of the media exposure was also a contributing factor, but I'm not an attorney.
Yeah, I think you're right about that. My question is, there were other factors in play. You may know that or you may not. Are you aware of that?
It's outside of my purview and role in this case.
That's not my question. My question is, do you know that that was in the order or not?
I will say no.
Okay. And we have had related cases related to this case tried here in Tallahassee. Are you aware of that?
I would assume you've tried cases in Tallahassee.
But co-defendants related to this case that we're here about have been tried here in Tallahassee. Are you aware of that?
I am.
Okay, thank you. In the spreadsheet, this was one, I think it was in Exhibit 1, Tab 1, where Donna Adelson and Charlie Adelson appearances in the media are lumped together. Are you familiar with what I'm referencing?
Is it the spreadsheet?
Yes.
Yeah.
Why were Donna Adelson and Charlie Adelson lumped together for purposes of that presentation?
I would have to speak with the client and the media monitoring team to see why that query was built that way. That would be my answer.
Were the numbers ever run for Donna Adelson alone?
I'm sure they were. In the course of testing queries, we run them many different ways. Ultimately, we arrived at a query that best captures the media exposure specific to what the parameters are around the case our client has asked us to be engaged on.
Okay, so I think that kind of gets to my next question. Who made the decision to lump Charlie in with Donna in the data included on Defense Exhibit 1?
I would say, I don't know. It would be a collaborative discussion between the client and our analysis team and our search strategist.
Okay, but ultimately, if you have data for Donna alone and data for Charlie and Donna together, who's going to decide what shows up in Defense Exhibit 1? You or the client?
It's going to be a combination. We would probably offer a recommendation since in these cases, either name is probably not in the news for another issue, and we often search to see if, I'll say, John Smith, if he's involved with the case as an alleged defendant or whatever, also has a car dealership that proves not, they will make a determination that if it would be statistically impossible to mention Donna Adelson without mentioning Charlie Adelson, we'll run the names together because the query is functionally one subject. Now, if either party in that query starts to exhibit a valuable comment on their own and not in relation to the other party, we would separate that and at least counsel our client that we should run this separately.
Okay, so are you able to tell the court how many of those articles that represent Donna and Charlie together, in how many of those does Charlie's name only appear in without Donna? So I'm not really after, I asked the question incorrectly, let me start over. I asked how many for Donna alone, but what I'm really interested in is how many does Donna's name appear in, period?
That would be done with you can do a simple search in the spreadsheet and search not for a name, Charlie, or only for Donna, and see how many of those 2,000 plus stories only mention one name.
Is that something you could do for us right now, or that's something that takes time and analysis to perform?
It would take, I wouldn't want to do it live on TV. I want to make sure we follow our methodology and protocol and have two sets of eyes check it.
All right, so you don't have that data to provide to us right now as far as how many does Donna's name appear in?
The data's there, we would just have to, or someone on your side or another could sort it.
Okay. When you're talking about opportunities to see a particular article or content, does that presume that all Leon residents actually have the same likelihood of seeing the content?
They all have an equal probability of being able to see the content.
Okay, but actual views could be consumed repeatedly by one viewer and not at all by another, correct?
That's a possibility.
All right, so if you're saying I had 376 opportunities to see this content, it's possible that I, as an individual, could have actually not seen any of it.
That is a possibility.
And it's 376 total opportunities over how many years?
I believe about 11.
Okay, and so I think in your math of memory, we can agree that the passage of time in general does not agree. So I would need to ask a particular juror, how long ago did you see the content and how much do you remember from the content to really know what that juror remembers, right?
To know what an individual knows or can reveal, that would be correct.
How many opportunities does the average person, adult, have in an average day to have an impression from any content? And I guess I'm thinking of, waking up, picking up my phone, scrolling this morning, turning on the news, riding to work, listening to a streaming service on the way to work. I've already been bombarded with a bunch of opportunities, haven't I? Just today.
I would need to know where you live.
Okay, but in general, let's just take the folks in this room that are sitting in here now. We've already had a lot of opportunities to observe content. Would you agree?
I would think so. I don't know you, so I don't know what your propensity to consume news is.
But you deal in averages, and you're telling us what the average adult has the opportunity to consume based on that data.
Right. So I think if you look at the control story for a car crash, that would give you your answer. Then it gives 6 opportunities to be seen or something like that.
Right, but we're bombarded with this stuff all day, every day, is my point.
I don't see relevance to the question for me.
Okay. All right, so can we agree that actual memories of an individual vary? I mean, again,
Yes.
Going back to what you were saying about I'm dealing with averages and probabilities, an individual might have differences based on their actual exposure to the content, based on their actual ability to retain information, based on their interest in the topic, based on what else is going on in their lives, their age, and lots of other factors. Would you agree with that?
I would.
You said the average person, the average Leon juror is, had I?
If I was the judge, and I know this has already been done and they lost the motion, but I'm enjoying this. I've never seen a change of venue hearing before. That answer right there, if I'd been the judge, that one answer would have been all it took to make me deny the motion. Because she's like, okay, so how many chances does the average person have to be exposed to something? Like, I get up, her little scenario she did, right? And then he goes, well, I don't even know where you live. What? That's your job, dude. That is your job. That's why you're here. That's why you're testifying in the courtroom, to try to help them figure out how many people have been exposed to this case. You deal in averages and probabilities. That's why you're testifying. You don't know where anybody lives. You don't know. And he's like, well, I don't know you. I don't know your habits. You don't know anybody and their habits and whatever, when you're paid to try to help them figure out who's been exposed to the information. That was such a crappy answer. He could have at least tried, made something up if he didn't know. At least given a better answer than that. Well, I don't know where you live. What was that?
Okay. And do we know how many of those 26 contain the name Donna Adelson?
All 26 stories would contain the search term. So these are 26 opportunities to see the specific story about, I believe in this case, Donna Adelson.
Okay, but it's got Charlie lumped in with it, doesn't it?
Right.
Okay.
Yes.
And based on those 26 opportunities, you talked about the math of memory and how after a certain number of exposures, a person is likely to retain some of that information up to the rest of their life. Are you able to tell us what information is likely to be retained by a juror who's had these 26 exposures?
Yeah, it's the test on that was can recall 80% of the details.
Okay. And so would it surprise you to learn that previously when we've asked jurors about this case, we get about a third that don't know anything, a third that know the headlines, and a third that have more detailed information? Does that comport with your work, or does that seem inconsistent with your work?
I'm unfamiliar with your procedure for selecting a jury.
Okay, but based on your analysis, does that sound about right, that that's what we would expect, or would you expect something different?
It's outside of my area of expertise. Jury selection I don't do.
But you're saying they would retain 80% of the information if they had been exposed 26 times. Is that what you're saying?
Yeah, I'm saying the probability of an average person in your county, I believe in Leon County, that would be the probability of an average person of jury selection age.
The probability of the average person of jury selection age who was in fact exposed 26 times retaining 80% of the information.
Had the opportunity to be exposed 26 times.
Okay. But they definitely have to actually be exposed to get any of the retention that we're talking about.
That is true.
And we can't know that unless we ask them.
Yes, I can. My work is in the probability of people before they enter your room. So all I can speak to is the probability of the people you might encounter during a jury selection process. I can't answer a question about who you will encounter during a jury selection process.
Right. Understood. No further questions.
I have a follow-up question, and from there the parties can follow up as they need to. Mr. Murphy, I remember when you were testifying on direct that you were stating your numbers as it relates to the probabilities rely on the taking of the last census, correct?
Yes.
In any way, do these numbers account for seasonal fluctuations or shifts?
In terms of immigrant labor, or?
Well, let me be more specific. Here in Leon County, we have 3 colleges and universities, meaning when you have a freshman class coming in each year, there are now 18-year-olds who will meet, presumably, juror eligibility. In that way, for that fluctuation of persons who may be eligible jurors by statute, does your data take that into account in any way?
I can't answer that without asking a question related to your fluctuating population. If you'd like me to ask that question, I can, Your Honor.
You can ask. I'm not sure if I can give you much more, but go ahead.
So in the case of students, I have 2 children who've gone through college. Do they need to be registered voters? I don't know what the statute says.
They have to have a driver's license that has a residency full for coming into the juror pool.
So we would have to look at, let's say you have 20,000 students that fluctuate at the university level. How many of those have a Florida license, and a valid Florida license, and how many do not? You can probably get that statistic directly from the university of how many out-of-state students attend each year.
Very well. And would this impact what your numbers and analysis are?
Probably at a very marginal level. Once you removed the out-of-state students and those who don't drive, then you're going to be left. If we started with 20,000 and removed those who aren't registered with a valid driver's license, the number would get down to a small enough number that may impact the population of jury-eligible students by maybe 10,000. A small number that statistically wouldn't shift this, maybe by a percentage, but nothing more.
No more. And I believe also you stated as well, you made a comparison of your data to Nielsen ratings.
Yes.
How closely would you say that mirrors? And the reason I ask this is because a Nielsen rating or maybe a radio rating, I think the science behind it, they try to make it as detailed as possible because they're trying to use that information to monetize it, correct?
Correct.
But ultimately, even with a rating of that nature, when, say, it's reported there were 200 million people that watched the Super Bowl, that doesn't tell us, did you watch every snap? Did you turn it off at halftime? Did you turn it on in the fourth quarter because it was a good game? It can't really drill down. It's just ultimately, this is the big number that watched the game.
Right, on gross number, that's correct. But when you're starting to get into the engagement level of the activity or the action within the media, so statistically you can measure that people are more probable to watch a tight Super Bowl game that goes into overtime. The eyeballs on that overtime are going to be higher than maybe the middle of the third quarter. So you can show some statistics around topics or activity within the content, and that's what you would see in the numbers presented as evidence of a car crash versus, say, a murder. Murders are always going to gain a higher probability of attention, are going to have a higher probability of attention than the topics we're desensitized to, like a fire, a car crash, a fender bender, a robbery, things that we see and hear every day and don't engage with because psychological behavior, we desensitize ourselves to those topics.
Very well. Any follow-ups by the state to the court's questions?
No, Your Honor.
Mr. Zellman, you may redirect us to all topics, including the court's questions.
Thank you, Your Honor. I'm going to share my screen again, Mr. Murphy. On cross-examination, the state asked you about the 26 opportunities to be seen. To be clear, Exhibit 3, during what time period did those 26 opportunities to be seen take place?
If I refer to the chart.
Let me actually share my screen.
Thank you.
Sorry.
So this is what the slide that we're showing now is the 1-year sample for comparison.
And so with the full set of data,
excuse me.
You can zoom in for the witness, Mr. Zellman, so you can see it clearly.
Thank you, Your Honor.
Well, not giving you the vision test again. Go ahead.
now the time period that is indicated in Exhibit 2 with 376 opportunities to be seen per person, what is that time period?
So that's July 2014 to January 2025. That would constitute what we know as the first story. The first story we sometimes either call the alpha clip, the alpha story, or the breaking news story. It should constitute that through the cutoff date in January 2025. In order to do an analysis, we have to have a specific starting and a specific end.
So during that roughly 10 and a half year period, there were 376 opportunities to be seen
in Leon County.
In Leon County. And then
per person.
And since then, since January, that number has remained constant or has it increased?
If there's been any media coverage, which we know there has been, then that number has gone up. But since we are presenting that in the analysis, I won't speak to how much. But I stated earlier, we are on track to exceed 2024 total opportunities to be seen based on media coverage and impressions. And when I say we, I'm referring to the media monitoring.
So going back to that slide on Exhibit 3, this is where you're indicating that 2025 is on track to exceed 2024.
Correct.
And so 2024 had over 92 million media impressions, correct?
Right. And that would speak to the fact that each individual of jury eligible age, that would speak to each person in that designated market area, in this case, the entire state of Florida, has the capability and has the prosecution pointed out, a person can consume more than one story. And as the model for memory shows, each time you see another mention, you have the potential to strengthen your knowledge on details about the story.
In slide 2 of Exhibit 3, you indicated in your direct testimony that this represented, there were some peaks and valleys when the volume of coverage was greater or lesser. So if I were to tell you that the initial arrest took place in 2016, would that correlate with the data where there was a significant increase in the number of stories?
Yeah, we would look through that number to make sure that you're correct, but that fact that you state is or would be indicated by that peak.
And the same in 2019 was the initial trial. Would that also correlate with the peak in the data that's identified in Exhibit slide?
Yes. Anytime there's an element to a long-running topic in the media of significance, you'll see a peak like that.
And so is it fair to say that the length of time, or when key events happen, such as trials, the media coverage increases?
Yes. And that's a simple function of the media. They want eyeballs, and they know what stories have interest to the community they serve, or may not have interest to the community they serve.
Just a moment, Your Honor.
Go ahead.
One last question, Mr. Murphy. Based on the analysis of the data that was collected in this case, is it fair to say that the overwhelming number of publications and broadcasts took place or were presented in Leon County?
Could you say that one more time, please?
Sure, sorry. Based on the analysis of the data that was conducted in this case, would you agree that the overwhelming number of publications and broadcasts concerning the story took place in Leon County, Florida?
That is correct, yes.
And that, just statistically speaking, Miami-Dade County, with a significantly greater population, has a significantly less media exposure in this case.
That is true.
Nothing further.
Murphy, that concludes your testimony during this hearing. You may remain on the Zoom if you desire to do so. And I'm now going to speak with the attorneys as to their arguments on law or any other evidence if they have to present it.
Thank you, Your Honor. Is it standard operating procedure that I will remain, or do people normally exit?
You can exit or you can stay. It is up to you, but you are free to go.
Okay. If I'm needed further, please let me know.
I'll call you.
Thank you, Your Honor.
Mr. Zellman, any other witnesses or evidence that you wish to present?
Your Honor, can we have a 5-minute recess, please?
That's fine. I will stop the clock during the recess.
Well, thank you.
5-minute break. Well, actually, we'll go to about 10:50.
Thank you very much, Your Honor.
So, friends, have any other witnesses or testimonies as part of the presentation?
No, Your Honor.
Very well. State, you may make your rebuttal presentation if you have one.
Judge, all I have is a thumb drive that I prepared as State's Exhibit 1. I intended for it to contain the 3 prior jury selection transcripts on the related cases, but for some reason we weren't able to find the first one, so it contains the most recent 2 transcripts of jury selections conducted in the related cases, codependent cases. I'd like to admit that for your consideration.
Is there an objection from the defense?
I don't think there's a legal objection to that, Your Honor.
States 1 as the thumb drive is admitted as well. Any other evidence or presentation?
Just argument, Judge.
You may make your argument, Mr. Zellman.
Thank you, Your Honor. Your Honor, as you're familiar with my practice, I tend to put it all on paper, and I did that in this case. I do want to highlight a number of items, though, Your Honor. In Exhibit 5 is listening to podcasts, 77 pages long, individual podcasts. There is some overlap between platforms. However, it's not just the podcast that we're asking the court to consider, but also what people are saying during those podcasts. The effect on the listener that those podcasts have and the comments that the public makes are where we are seeing the most significant prejudice. The vitriol towards Mrs. Adelson, to her son, to her daughter, and we also see in those a number of podcasts. I ran a search yesterday. I counted over 20 different episodes just focused on inadmissible information. As Your Honor is aware, prior counsel in the state, you had an in-camera hearing last September. I'm not going to go into detail about what was contained in that. Unfortunately, back in December, when Your Honor authorized that to be transcribed, it was not sealed when it was posted to the clerk's website. Media outlets from all over the country obtained that information. They obtained the transcripts, they published the transcripts in full, they analyzed them in their podcast, so now what Your Honor has ruled to be inadmissible is out there. It's out there, and as I said in my motion, you can't unring that bell. One of the factors is whether the publicity has included information that would be inadmissible at trial. In addition to that inadmissible information, we still don't yet know which audio recordings the state intends to seek to admit in the trial. However, there are audio recordings that we submit would not be admissible against Mrs. Adelson. It's our position, Your Honor, that co-conspirator exception, the conspiracy ended when the murder took place. Conspiracy did not continue to extend beyond that. As a result, any of the statements that were made in 2016 on the watch by other individuals, other than Mrs. Adelson, are not included under the co-conspirator exception. And those would be...
We would have to, I think, handle this through a separate motion in limine or argument as to that hearing, but as to the completion of the murder being one part of it, yes. As the conspiracy being ongoing for the conspirators never to reveal what their role is that ever end, Mr. Zellman?
I'm sorry, what was the last part?
For the persons who may have participated in the conspiracy, would that not always be an ongoing thing, so their role is never revealed?
The way that this is charged, Your Honor, I would say no. It's charged with conspiracy to commit a murder, not conspiracy to cover up a murder.
Very well, please continue.
So you have, it is our position, inadmissible information that has been publicized. And it's nobody's fault for the vast majority of the information. This case has been tried 3 times. Each trial has been live streamed. All of the testimony has been publicized. So as to what could have been done prior to our involvement on behalf of Mrs. Adelson, all of that evidence was already out there. And it's our position, Your Honor, that with respect to those statements that are not admissible as to Mrs. Adelson, and to back up, Your Honor, once the state identifies which wire recordings they intend to use, we certainly will file a motion in limine, ask for a pretrial ruling, so we're not dealing with that during trial and potentially wasting the jury's time. But we can't do that just yet, because we have to wait for them to identify the calls.
And you're referring to the most recent wiretap or the wiretap from 2016?
Both.
Very well.
Another factor that Manning tells us to consider is the timing. I'm sorry, Preston and Oates tell us the timing of publicity relative to the incident in the trial. So historically, courts have said, okay, well, we're going to continue this trial a year, 18 months, 2 years, so that the original publicity has died down, and that won't factor into potential jurors' minds. That's not something that exists in this case. That's exhibit, let's see, I believe it's exhibit 3, indicates the publicity that has taken place in this case has not died down. There's been an ebb and flow over the years. So initially in 2014, there was, obviously that's when it first happened, there was significant coverage. That died in 2015 during the investigation. And then in 2016, once the arrests were started, the initial plea by Mr. Rivera was entered, and Ms. McDonough was arrested, there was a great deal of volume of coverage. 2017 and 2018, it died down. 2019, first trial, it increased significantly. And then in 2020, 2021, it died down. 2022, during Ms. McDonough's second trial, 23, for Mr. Adelson, Charlie Adelson's trial, 2024, 2025, all of those increase. And as Mr. Murphy indicated in his testimony and in Exhibit 3, specifically slide number 3 of that exhibit, the media coverage in 2025 is on track to suppress last year's totals. Last year's media impressions exceeded 92 million. So that tells us that the timing of publicity, it's not going to die down. It's going to continue to circle. I mean, we're sitting here, we have reporters typing behind us. This hearing is probably being broadcast live. And so that weighs in favor of granting the motion.
Do the defense filings or filings by the state in particular play any role in those?
I'm sorry?
Do the defense filings or filings by the state, the pleadings, play any role in those?
I don't know that I can answer that. It's one of the reasons I think that we had filed the materials in support of this motion under seal, so that the information was not highlighted again for the media. We obviously, court records are public with limited exceptions. So I don't know how that factors into it.
Very well. You may continue.
With respect to all of the podcasts that have been identified in Defense Exhibit 5, as well as any commentary that is contained within those podcasts that members of the public are able to provide their own insight on. Your Honor, reviewing that information, it becomes clear that the community's hostility towards the defendant is overwhelming. The sentiment from all of those podcasts, not necessarily the host of those podcasts, but for a vast majority of them, yes, for the host, but for the people who comment on those podcasts, the vast majority of it exhibits hostility towards the defendant. And in almost every single one of them where you have the talking heads offering their opinions, the vast majority of them offer their opinions about Mrs. Adelson's guilt or innocence and are publicizing it, and the vast majority are saying that she is guilty. And they are skewing the reporting in a way to support their theories. All of that's in evidence, Your Honor. I'm asking the court to consider that in reviewing the factors that the court is supposed to consider. And I want to highlight, Your Honor, before I wrap that up, actually, there's another factor that needs to be taken into consideration, and that's when a confession is featured in news media coverage of a prosecution. Confession of Mr. Rivera and Catherine McBanoa has not only been published, but their testimony has been broadcast on live television, summarized in local print news media, as well as the podcasts. Now, I recognize...
Let's break them down as individuals, because with Mr. Rivera, I believe his testimony has always been that he went and did a murder for hire as a paid job. He did not know who essentially the principal was, but it was organized through his friend's girlfriend.
Correct.
In that way, how exactly is that a confession that implicates your client?
Well, I'm trying to find that part here. Let's see. I guess, Your Honor, Mr. Rivera is not as significant a factor as the testimony of Ms. McBanoa. Her testimony in Mr. Adelson's trial, her proffers, transcripts of which have all been released to the public, and the recordings of which I presume have all been released to the public, detail her recitation of what happened and directly tie into Mrs. Adelson's alleged involvement in this this murder. So, now I recognize that factor comes from Oliver. As I indicated in my memorandum, recognize that Oliver has been restricted and refined. In Hoy, one of the cases that restriction refines Oliver, the detective summary of the confession was published, as well as 3 contradictory statements made by the defendant. Here, no statement by Mrs. Adelson has been published except for the statement that was released, I believe, back in 2016 by her then attorneys, denying any involvement. However...
That was a statement she made, or just that the attorneys made in response to a press release?
It was a press release from her attorneys.
Directly quoting her, or just on behalf of the family in general?
It is on behalf of the family. That's the only thing, I believe, that has been published on behalf of Mrs. Adelson, but it's not a statement directly from her.
Please continue.
So you have the confession as another factor there. And what I want to say, Your Honor, is quoting from Singer v. State, the Florida Supreme Court said, every trial court in considering a motion for change of venue must liberally resolve in favor of the defendant any doubt as to the ability of the state to furnish a defendant a trial by a fair and impartial jury. Every reasonable precaution should be taken to preserve to a defendant trial by such a jury. And to this end, if there is a reasonable basis shown for a change of venue, a motion therefore properly made should be granted. A change of venue may sometimes inconvenience the state, yet we can see no way in which it can cause any real damage to it. On the other hand, granting a change of venue in a questionable case is certain to eliminate a possible error and to eliminate a costly retrial if it is determined that the venue should have been changed. Your Honor, it's our position that although a jury has been seated previously, the media coverage, and again, when I'm saying media coverage, I'm referring not just to print and broadcast, but also to the podcast that are in evidence, overwhelmingly points to the fact that seating a fair and impartial jury in this venue is going to be impossible, and in order to avoid the expense associated with making that attempt, the court should now grant the motion for change of venue.
As to both Singer and the cases that follow it, does this argument account for the most recent Florida Supreme Court precedent on this topic? The cases that go to not only must there be prejudicial media coverage, but there was an attempt to see a jury and you could not seat one.
Your Honor, it's our position that the case law is still valid. I'm not sure exactly which case Your Honor is referring to. I'd be happy to look at it.
Smith versus State, 320, Southern 3rd, 20. Case from 2021.
I'm sorry, Your Honor, you said it was 320 Southern
3rd, 20. Donald Smith versus State of Florida, and deals with, this is a death penalty appeal, but deals with change of venue along with other issues. Cites to Griffin versus State and Rawling versus State, and deals with the issue of pretrial publicity.
Can I have a moment to review that, Your Honor?
Go ahead.
Your Honor, just briefly reviewing Smith and Griffin, both involved in analysis of fundamental error. In both cases, trial counsel did not obtain definitive rulings. One of them, I believe in Griffin, Your Honor, trial counsel didn't file a written motion, brought it up just before jury selection and didn't object when the veneer was sworn. Smith, same issue happened there. Smith attorneys did not renew their objection or request a final ruling on the motion for change of venue after the jury was selected. So those, I believe, are distinguishable from what we have here.
Ultimately, with that, we are not talking about an issue of review for fundamental error, as no review would even be right yet. At this point, regarding a change of venue, a trial court must make a two-pronged analysis, evaluating the extent and nature of any pretrial publicity, and the difficulty encountered in actually selecting a jury. As to that, is that the applicable test the court must use?
I would say that applies when jury selection has been attempted, but my research indicates that no Florida Supreme Court case has overruled the test set forth in Singer that pretrial publicity on its own can still be a basis.
As a point of law, I don't believe your reading of Singer is wrong. However, these cases are refined over time. I believe Singer was 1959.
Yes, sir.
Cases that are almost as old as my father. They're still good, but they do change over time.
I agree, Your Honor, but it's the case law also cannot be overruled by implication. No higher court, no Florida Supreme Court case has said definitively that Singer is no longer law.
Very well. State, you may provide a rebuttal argument.
Judge, what I learned from the defense expert is that there's been a lot of publicity in this case, which I think we all already knew, as is their right to report on a case that's been of high interest to this community, and that we have a high probability that we'll encounter some prospective jurors who know something about this case, something I think we all already knew. What and how much and whether they formed a fixed or definite opinion are factors relevant only to those individuals and can only be learned at jury selection. Similarly, who has consumed inadmissible
discussions of inadmissible evidence. We can only learn that by asking them who's listened to these particular podcasts, and I trust that the defense will do that. I also expect that it will be relatively few. Maybe I'll be proven wrong, but again, the fairness that we're guaranteeing her of this trial is through that jury selection process, that those jurors will be asked those questions and that if appropriate, they will be stricken. To secure a change of venue, the defendant has the burden to show this court that there is a reasonable likelihood that prejudice against her in our community will prevent her from receiving a fair trial. How do we know if the facts or the media coverage of a case has prejudiced us such that the citizens of this community where this crime occurred are not capable of rendering a verdict based solely on the evidence that's presented in court, except in the most exceptional circumstances, which I can imagine, to answer your question about Smith versus Singer, I can't imagine, maybe a George Floyd or a circumstance where the answer might be to avoid attempting to pick a jury because there's no point there. But this certainly isn't a case like that. The defendant in their own motion cite Lozano. Lozano is a third DCA opinion, not binding on this court, and distinguishable from our case. But according to Lozano, a change of venue is appropriate where legitimate community safety concerns might influence a jury's verdict. Lozano was a racially charged incident in which a Miami police officer shot and killed a motorcyclist and a passenger, whereby they then crashed into two other citizens, injuring them. And it sparked protests in that community immediately upon the incident occurring. There were riots in the Miami area, which caused school closure. The 130-block area of the town was cordoned off for crowd control, and use of tear gas was deployed against. The court said that a fair trial could not be conducted in an atmosphere in which the entire community was so obviously, penetrated by the feels that resulted from this incident, which was basically like a lightning rod in the community. And the court
literally couldn't get through the courtroom door, essentially, to start the case.
Right. I mean, I can imagine a situation where you can't pick a jury under a situation like that, where the jurors are potentially concerned about their own safety or the safety of the community if they render a particular verdict over the other choice. Dan Markel's death was felt deeply by many in this community. I certainly would never argue the contrary, but it's distinguishable from an incident like Lozano, which involved a community reaction driven by underlying social, economic, political factors, widespread fears within the community, and is prone to sparking something like a violent outbreak. Nobody's going to start a riot based on Donna Adelson's verdict, whichever way it goes. Next, defendant cites Manning, a case in which there was a change of venue granted, but that cites McCaskill, where the test for venue was set forth, or the test for change of venue, I should say, but in which, in McCaskill, the motion for the change of venue was actually denied. And the court said a determination must be made as to whether the general state of mind of the inhabitants of the community is so infected by knowledge of the incident and the accompanying prejudice, bias, and preconceived opinions that the jurors could not possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. What the defendant left off of that quotation in her motion was the sentence that preceded that quote that I just read, which states, knowledge of the incident because of its notoriety is not in and of itself grounds for a change of venue. All we've got right now is suspicion that several jurors are going to have knowledge of this incident. We have a case that's gotten a lot of media attention and has gained notoriety in our community. But to conclude that this case has rendered our entire citizenry incapable of giving Ms. Adelson a fair trial there's no evidence to support that. Manning was also a racially charged case involving the murder of two well-liked white deputies by a young black defendant in a small rural community. There were about 31,000 people in Columbia County in 1976 when the Manning case occurred. A voir dire inquiry in that case revealed that every member of the jury venire had significant knowledge about the crimes. That is not what I anticipate we'll have here. It's distinguishable from this case where we have successfully selected 3 prior juries on related cases under similar circumstances with similar media attention. And I would reference states 1 for that, which is the transcription trials 2 and 3.
Well, to that point, and I don't think the state is really disputing the mathematic analysis that has been provided by the expert, there has been a spike as the various trials have gone on, correct?
Sure, there's more content out there. I think some of the content is the same that's being hit over and over. And I think the problem with the analysis from the expert's perspective is that we're just going to divide all the content by all people and spread it out evenly among all the people. And that's just not how the world works. Some people are going to pursue content. Some people aren't going to see it at all. Others are going to just look at headlines. Those people are still eligible to be jurors unless they formed a fixed or definite opinion about guilt or innocence based on those headlines. So to divide all content by every eligible juror and say, oh, you've all got 376 exposures to this, you're all ineligible. It's just fuzzy math.
So you're saying going from the general of what the math might be to the specific of if we take a random person off the street, we still need to ask, what do you know, what have you heard?
I think so.
Please continue.
I think that would be appropriate in this circumstance. I'm not saying it must be necessary or required in all circumstances, but certainly here, where the media content, yes, there's a spike because something's going on, stuff is happening, but it's the same, I think, going to turn out to be the same people consuming this stuff over and over and over again, and those people probably won't be eligible to be jurors. But as we've learned from experience, there's going to be a lot of people that are still eligible, and I think we should at least try before we take this case away from the county in which it occurred and move it elsewhere. Certainly, I can't imagine a planet on which we move this case to Miami, which seems to be suggested by the defense. I mentioned when I was cross-examining the expert who had no knowledge of this, but I think that State's Exhibit 1 will reflect that about a third in our individual voir dires on previous jury selections had no knowledge of this case, which might be surprising to some of the people in this room who are consuming it regularly, but not everybody consumes this stuff. And about a third had very limited knowledge. Those people are still mostly eligible to become jurors. And then there's a third that have more detailed knowledge, and some of them didn't have fixed opinions and were still eligible to become jurors in the case. So while many jurors were disqualified in those proceedings based on their knowledge and their feelings about the case, there were plenty that weren't. We picked a jury in 2 days on the first 2 trials and then 3 on the third. On the third trial, we had a defense jury expert flown in from Manhattan to drill down specifically on individual voir dire regarding publicity. And that was a time-consuming process, and we still were able to successfully get an unbiased jury that was agreeable to both sides in 3 business days.
I'll review your exhibit, but do you recall of the jury that was actually selected, what was the breakdown of no knowledge, some knowledge, or stated they would set their knowledge aside?
My recollection is that it was roughly a third, a third, a third. But
And this is the most recent jury?
Yes.
Go ahead.
I've just noticed that pattern both in voir dire, who we end up with, repeating itself throughout, my life that has become this trial. It's happening over and over again. So can I say specifically that what we ended up with was that breakdown? No. But that has been my observation over time. It's like, gosh, there's a third of the community out here that still has never even heard of this thing. So I'm suspecting they're still out there. There has been a peak. Maybe we'll try and learn otherwise, and it won't be possible. I don't think that's going to happen, though, Judge. We're going to weed out the folks that are not eligible until we get down to a panel that's acceptable, and then we're going to proceed with other questioning. Since we've selected, 3 jurors previously, I don't think this recent spike in activity in media is going to somehow make it impossible to get a jury this 4th time. I did want to cite Copeland v. State. I have a copy for Your Honor in the defense if you'd like, but it's at 457 Southern 2nd, 10-12-1012, a Florida Supreme Court case from 1984, in which the court held that a widespread public knowledge about the case is not the focus of the inquiry on a motion for a venue change based on pretrial publicity. Rather, the critical factor is the extent of the prejudice. So what is the prejudice? Defense has really only pointed to these podcasts with opinions about guilt and inadmissible evidence being discussed to really talk about this hostility and this prejudice that's out there. And I think we need to ferret that out through the jury selection process to determine whether that has really infected the jury venire as a whole. I think we're going to find that it has not, and none of the expert testimony related to that. The court goes on to say in Copeland that if it is possible to impanel a jury that can be relied on to decide the case based upon the evidence and not be influenced by knowledge gained from sources outside the courtroom, then a denial of a change of venue is proper. Again, in Copeland, every member of the jury panel had read or heard something about the case, but because all of them said they could set aside that information and render a verdict based solely on the evidence presented in court, the motion for a change of venue was properly denied. I also want to draw your attention to Hanyard v. State, H-A-N-Y-A-R-D, at 689 Southern 2nd, 239. It's a Supreme Court case, Florida Supreme Court, 1996. This was a death penalty case in which the court said that absent extreme or unusual situations, like what we saw in Lozano maybe, the need to change venue should not be determined until an attempt is made to select a jury. And this goes to the Smith case that Your Honor brought up earlier. In Hanyard, again, all the prospective jurors had heard something about the case, but each agreed they had not formed a fixed opinion about guilt. Each agreed to consider only the evidence presented in trial in making a decision, and so the motion for a change of venue in that case was also properly denied. We have not yet attempted to select a jury, but we have every reason to think we should, as recommended by the Florida Supreme Court. Your Honor brought up Rawling v. State, and I highlighted that one as well, that outlines the 2 prongs. Prong number 1, the extent and nature of the publicity. We do have extensive publicity, but I don't think we have sufficient evidence that the nature of it has been improper or inflammatory such to infect the jury venire as a whole. And the second prong, of course, is the difficulty encountered when actually selecting a jury. Again, we should, but have not yet tried to select a jury. And again, previous efforts to suggest that we will be successful in selecting a jury in this case. In page 3 of defendant's motion, she relies on Oliver for the proposition that published confessions should be for venue change. Oliver was a case in which the Tallahassee Democrat published a summarized transcript of the defendant's confession before his trial. I think Your Honor got to this a little bit in your questioning of the defense, but Oliver's not applicable here because there is no confession here. If there's a confession of Donna Adelson, could someone please send it to me post-haste? So hence, the confession of Donna Adelson has not been published. They cite the testimony of co-defendants, Magdano and Rivera, which one is not the same thing as publishing her confession as what happened in Oliver, and also neither of these witnesses really offer testimony tantamount to a confession, Donna Adelson, which I think Your Honor pointed out. In addition, it should be noted that the Oliver case happened in 1968. Another factor Your Honor mentioned in your questioning of the defense, several of their cases happened quite a long time ago. The population of Tallahassee, according to Google, not very official source, was 68,000 in 1968. And when I'm guessing that the Tallahassee Democrat, no offense to my friends, was probably reaching a higher percentage of the community than they do today because of how many options we have today, how much media is out there, and the ways it has to reach us through our phones and otherwise. Today, as evidenced by inquiries of hundreds of prospective jurors in the last 3 related trials, as evidenced on State 1, many jurors abstain from local media entirely, choosing to get news online or from national outlets, an option that was just not available in 1968, or some of them abstain from news entirely. Say, I don't watch the news. All right, so all the analytics provided by the defense presume that all the prospective jurors have had equal opportunities to review these stories, and that's simply not the case. Not all prospective jurors consume media the same way. They don't all watch any media that has anything to do with this case, and they certainly don't all do it with the same amount of thought or attention. All of this is fair game for exploration at jury selection and should be attempted before taking this case out of Leon County. There is reference, I thought we'd get more into it with the expert, we really didn't get there, but in the motion there's some sort of, there's subliminal mind control that the media does on us, which we don't really know, we can't really record at jury selection, but we might be biased and not be able to spit it out at jury selection. So to that I would say, until somebody comes up with a better system, we should stick with the one that's worked for over 200 years, which is the best we have, which is to ask them and rely on their statements under oath about their inner thoughts and feelings. I mean, if we have to read their mind to know what they're really thinking, they could be thinking a lot of things that could potentially disqualify them as jurors, not just related to guilt or innocence, but lots of other biases. So we obviously don't have a crystal ball, we don't have the ability to do that, and until we do, all we can do is ask them and rely on them, which I, observe jurors to take their oath seriously and to report as well as they can their inner thoughts and feelings on the subjects that we're inquiring about. The defendant's motion concludes with a citation from a concurring opinion in the Irvin case about the inability of a juror to set aside information that has saturated the media. Here again, the statement was authored in 1961 when it was possible for a media outlet to permeate a community in a way that is no longer possible. Irvin is, of course, still good law, as are all of these old cases that we're talking about, but as Your Honor pointed out, it's your decision it's within your discretion to make a decision based on the circumstances of this case that are present today, which are significantly different from 1961, in which very few women sat on juries because they were only eligible if they voluntarily registered with the clerk, expressing a desire to be placed on a jury list. That's how we did jury selection in 1961. How many volunteers do you think we did? We ran jury selection in that manner forever.
Things have changed. Time moves on.
In addition, in the Irvin case, that took place in Gibson County, Indiana, population 30,000 back in 1961. Again, very different from the demographics that we have here and the population we have to choose from here. One consideration suggested by the Rollins Court is whether the media coverage in this case has been particularly inflammatory. And I mentioned that. I think the podcast could potentially rise to that level, and we certainly should inquire of the jurors whether they have been exposed to things like that. But on page 7 of her own motion, the defendant offers 12 bullet points of what she presumably considers to be the more inflammatory local headlines, none of which are particularly unusual, and only 2 of which mention her specifically by name. The motion goes on to state that her name and image could evolve into an unconscious negative conditioned stimulus when associated with words such as murder. And we digress there into an absurd result where the media can no longer report who in the community has been arrested for murder without creating an unconscious negative unconditioned stimulus, such that nobody who reads that newspaper can participate in jury duty. In conclusion, today's media landscape is a smorgasbord of opinion, news, fake news, and everything in between. For better or worse, most of us navigate that information jungle to seek out, or at least train the algorithm to feed us the stuff we want to see, the stuff we want to consume, rather than being fed, in 1961 in Indiana, what the editor of a local newspaper wanted us to learn. I mean, I get golden retriever videos. I've probably gotten 367 golden retriever videos, and I certainly couldn't recite 80% of them, for Your Honor, if a gun was to my head. As evidenced by the prior jury selections and the related trials in this case, there just aren't that many jurors that are saturated with local media anymore. Just because the local media is turning out a lot of material doesn't mean that our jurors are consuming or retaining or forming opinions based on that material. There is a local community interest in seeing justice to be served in this case, and there's not a legal basis to move it. The jurors that have been exposed will be appropriately questioned and stricken based on their answers. It is a bedrock principle of American criminal law to try the case in the jurisdiction where the crime occurred. The defendant has failed to show that Leon County is inherently prejudiced against her, and as such, the state asks that you deny the motion, proceed to jury selection here in Leon County.
Well, as the relief that you're asking for, is it possible also for the court to reserve ruling and still have jury selection?
You asking me?
I'm asking you.
I think so, Judge. I think you might have to readdress it if you attempt to pick a jury and cannot seat an unbiased jury in this case.
Mr. Zellman, in response.
Yes, Your Honor. First, Your Honor asked the state some questions about the jury selection in Mr. Charlie Adelson's case.
What was the breakdown of no knowledge, some knowledge, or could set knowledge aside for who was picked?
So I'm reviewing Mr. Charles Adelson's initial brief on appeal. That brief indicates that there were 130 potential jurors that were interviewed on an individual basis. Of those, 96 had heard about the case. Of those 96, 53 believed that he was guilty.
Those persons were never actually selected to serve on the jury.
Correct. The brief does not give a breakdown of
who was actually selected.
Correct. Now, I will say, Your Honor, that Your Honor will recall that there was one potential juror who claimed a lack of knowledge about the case. And in fact, that individual had posted negative.
I recall who. He was also shown the door.
Yes.
Therein, what is the prejudice?
Well, that just begs the question. Does that mean that anytime you have a case such as this, you have to hire a consultant such as the one that Charles Adelson hired so that you can get that information and be able to present it to the court? I don't think that that is the way that we should look at things, Your Honor. Now, in response to the state's other arguments, the state has presented no evidence to contradict the studies that are cited in the defense memorandum. Historically, courts have attempted to mitigate the impact of pretrial publicity by conducting that individual voir dire. Unfortunately, the research concludes that that type of attempt to mitigate pretrial publicity is ineffective. Although I recognize that that is the approved, the courts historically have approved that method. However, the psychological research that is identified in the memorandum all stand for the proposition that that's just not how things work with the human brain. Just because somebody asks you, have you seen an article about Professor Markel's murder? Have you read any of the articles concerning Mrs. Adelson's alleged involvement? Have you formed an opinion? Unless you call somebody's attention to the specific article, it might not trigger that memory. That's what the research shows.
Before you go on that point, and I think in that way, this is where the constitutions have the interplay with each other. Obviously, Florida can offer more procedure or process than what the federal constitution requires.
Yes, sir.
As federal juries are selected, the judge essentially drives the process, questions of venire. Does not the Florida procedure give you more rights and more ability in terms of how that jury is selected to drill into those issues of bias?
Yes, Your Honor. I'm not going to comment further, but yes, Your Honor. The procedure in Florida does give us more protections than if we were trying this case in federal court.
So between a pre-screening and then also a full questioning, you still believe that bias cannot be ferreted out?
Given the way that the human brain works, I do believe that, Your Honor. I will say, Your Honor, and this is contained in a footnote in my memorandum, if the court, it's footnote 3, if the court decides to defer ruling or to deny the motion, the defense would request additional peremptory challenges as was approved by the court in Hawaii.
Very well. I will review all of the exhibits that were admitted as a part of the hearing today that I was not able to do so prior to the hearing. I believe the jury selections for McDaniel and Charles Adelson are the state's exhibits. The charts and graphs that previously were updated or I did not have access to. A written ruling will be issued. We are in recess.
Your Honor, can we reserve to file a supplemental affidavit to address the concern that Your Honor raised at the beginning of the hearing?
You may.
Thank you very much, Your Honor.
So that's the end of that. Okay. Thank you guys for coming out. I think we are caught up as we're going to get with pretrial hearings on her. Tomorrow morning, we're going to start the Betty Broderick trial at 8 o'clock. It looks like this trial is going to start on Friday, maybe even Thursday. Judy and I will keep an eye out as we watch the beginning of the Betty Broderick trial on Wednesday and Thursday, just in case we start this one on Thursday. But other than that, expect, just like we've been doing, 8 to 9, 9:30-ish on Betty Broderick, and then we'll go to the live trial of Donna Adelson. It's supposed to last for 2 weeks. Betty Broderick's trial is nowhere near as long as Phil Spector's was. So it's not going to be months and months and months like the last one was. So it's not going to take us near as long. I've got you guys set up to go over to Mike's. He's live right now. And enjoy your evening. I have to go cook dinner for my husband. And remember, be kind to people. Love your family. And Jesus loves you, and so do I. Bye, guys. Have a great evening. I will see you in the morning at 8.